So today's agenda for us in revision of your CA foundation law, like I said, revision we are going to do in a reverse manner, where we are going to now revise Indian Contract Act la consideration chapter. Which chapter, guys? Consideration. Okay. So all we are going to do is, I'm just repeating because if somebody is new here, somebody is new online, we are just taken the last 6 years resource from 2018 till September 2024 and taken all the case study based questions only. In this chapter, you will not find in my book what are the rules of consideration. No, only case study based question. So let's quickly see unit 2 consideration of Indian Contract Act has only 3 questions in exam. Only 3 questions. What is the first question? Rules of consideration is one. Under that you have rules like consideration can be executed, executory, consideration can be past, present or future, consideration need not be adequate. Do you recollect those points? Next, the second question you have what? Doctrine exceptions to doctrine of privity of contract, and last one is no consideration, no contract. For that we have some exceptions. In 10 minutes, even if somebody is studying for the first time, we will basically see how we can remember all these points. Okay. Now, yeah, I hope online it's all clear. Any doubts, feel free to unmute and talk, guys. Okay. Now, how do we remember these points? Okay. Sir, எனக்கு இந்த points remember பண்ண கஷ்டமா இருக்கு sir. You have to be smart. Sir, I'm going to skip unit 2 consideration, sir. இருக்கிறதே 3 question. ஒரு mandatory exam question. Who will skip? Okay. How to remember all these points? Let's take exception to doctrine of privity of contract. Like I said, in 10 minutes I will revise the whole chapter. I will spend most of the time in these questions. Okay. Now, very easy to remember these points. Can you tell me what are all the exceptions to doctrine of privity of contract here? The points that you remember, which is there in study mat. We have study. What are the points, guys? Agency in case of trust, then family settlement, marriage contract. You can see and tell. Next, covenant with land, then sorry, வருது சார் இப்போ வருது இப்போ பாருங்க. same link. Okay, what is the next point? Sorry, acknowledgement of debt, then one more, assignment of contract. Correct? Assignment of contract. Correct? Are you following, guys? These are the points which comes under the side heading of which one? Doctrine of privity of contract. What is this concept basically saying? Sir, if two people are fighting, if two people have an argument, let the two people have the argument by themselves. I will repeat again. Husband, wife are fighting. What you should do? See, buy some popcorn. That's it. No, then they came to the road in the building. You are the neighbor. Husband, wife came to their neighbors. Okay. They came to the road and they started fighting. What you did? Ayo, why are they fighting? You went to stop that fight. What will happen? Correct? Yes. Okay. So, what this concept is saying, if a contract is entered between two parties, only they have the right to sue each other. ஏக்கும் பிக்கும் சண்டை சார், நீ யாரு? சி, உன் வேலையை பார்த்து போ. Don't interfere in that contract. Are you following? I'm again repeating. If in a contract between two parties, only they can sue each other. Are you following, guys? A went and slapped B. As C, you can only see. You should not interfere. Are you following, guys? But for that, these are the exceptions. I will give a few examples because this is not a full concept class. I will give a few examples. Okay. Now, take family settlement. Father wanted to give property for 3 kids, son 1, son 2 and son 3. In the will, father gave only for son 1, son. Okay. Son 3 got angry. Can he file a case? Yes. How many times we saw, how many movies? Padi movie story that only. So here you can't come and tell son 3 is not involved. Why is he filing the case? He will come and file the case. Are you getting it? One more example. Let's say assignment. What is assignment, sir? I'll give an example. Let's take a pharmacy. Okay, I'll give an example for assignment. Let's have a pharmacy. Then let's have ICICI insurance and let me have staff. Okay. Or why pharmacy? Let me keep Apollo Hospital. Okay. In Apollo Hospital, there is staff. Now, whenever you go and work in big companies in the future, that big company will pay insurance premium for you. Meaning, you will get insurance from ICICI Insurance or ICICI Lombard, but who will pay that? Apollo. That means the contract of insurance is between Apollo Hospital and ICICI, but I am only getting the benefit of that. It's like father purchased pizza for me, I am enjoying. Like that, when benefit in a contract is assigned to somebody, sir, I'm giving you assignment, sir, do the homework, write 10 times. Like that, insurance contract or a benefit is assigned to whom? Staff. Tomorrow, after 10 years, if ICICI is not paying the money, who can sue them? Apollo also can sue because they're party to the contract, or staff also can sue. Are you following, guys? Like this, these are some examples. In exam, they have rarely now asking what are the exceptions of doctrine of privity of contract. If they ask, okay, these are the exceptions. Now, how to remember these points? I will write A cube. I'm going to give you a mnemonic. There are 3 points for A. Agency, assignment, acknowledgement of debt. What are they, guys? Agency, acknowledgement of debt and assignment. Okay. Now, next, sir, how to remember the other 4 points? You gave only for first 3. We can easily remember. Will you marry anybody of yours randomly like that? Yes. Will you simply marry someone randomly, guys? Online, everybody? No. For marriage, what is the most important thing? Trust is important, correct? After marriage, you can't take the other person's phone and daily keep doing audit. I will check. No. For marriage or any relationship, most important thing is trust. You have to trust the other person. If you have that doubt, then that means that you are not in the right relationship, correct? So trust is the most important for marriage. The minute marriage takes place because of trust, what happens? 2 families comes together. So families are settled. 2 families are settled because of marriage. So because of trust only marriage will take place, and because of marriage 2 families are coming together. Then mostly in this marriage or family, எதில் சண்டை வரும்? காசில். They will get money in fight for money, all of that. Nothing but land. I want that land. That land is mine. This land is yours. Covenants running with land. Covenants na enna sir? Covenants means conditions with land. ICA is saying you can come to the foundation exam only. I'm repeating, you can come to the foundation exam only if you, let's say, come with a Rolex watch. You can come to ICA exam only if you come in cab. These are conditions. You can come to class only if you wear blazer and come. These are called conditions. Condition is called covenants with land. So now you know all the points. A cube plus marriage. So I will write basically instead of A cube, I'll write triple A. Okay. Assignment, agency, acknowledgement plus trust leads to marriage, leads to family settlement, leads to land problems. Covenants running with land. That's it. I remember for exam. Now side headings only is the challenge. So doctrine of privity of contract exceptions. Everybody online repeat with me guys, because I know you all know concepts. We are close to exam. My goal of this class is to help you remember, revise the concepts quickly and focus on exam presentation. So quickly, agency, assignment, acknowledgement, trust leading to marriage, leading to family settlement, leading to covenants running with land. Are you following guys? Now next we'll remember the next side headings easily. Now I'm sure all of you can tell the points without seeing easily. Like this we will do for this also. No contract, no consideration. I'm sure all of you know these points. What are the points? Everybody online participate with me guys. If you're going to just look at my face like this in an online class, how many of you are there? Then there is no point of having online class. I will end the class. Sir, already you started late. No problem. I will start late only. I will end this class. Here students will listen. I will give you recording. You watch the recording. Those who are online, those who have doubts, unmute, ask your doubts. Put it in the chat. We have a lot of students online. Put it in the chat guys. You are woken up in the morning. In next 20 minutes, we are going to finish unit 2 consideration fully with questions. After that only food. Okay. Online, any doubts? Yes. Yes guys. No, no doubts. Okay. Superb. Thank you for confirming. Let's proceed. End of the session, consideration chapter, let me finish. Give me another 20 minutes. Then you guys tell me, sir, is this style okay or not? Okay. Next. No contract, no consideration. See the book and tell me the points, guys. Quickly participate. Tell me all the points. Put in the chart. Don't look at my face. Yes. Natural. Love and affection. Then past voluntary service. Excellent. Online can unmute and talk. Next. Agency. Then we have bailment. Completed gift. Time bar debt. Charity. Then that's it. Bailment. I wrote everything. Now, sir, how to remember these points, sir? Headache, sir. Why are you making me mug up? Don't worry. CA inter law. I will guarantee you, because I take law for inter and final. What mug up? Nothing is there to mug up. Like this points and all is not there in inter. Inter, you should remember the concepts. That's it. Remember the limits. Like how in Companies Act you have small company when limit is there. Turnover 40 crores. Paid up share capital 4 crores. One small company limit is there. Like that we have 50 limits. That's it. Okay. Easy ones. Okay. Now here only we have to remember side headings. First let me brief this concept. No contract, no consideration. It's actually opposite. No consideration, no contract. Okay. Let me just write that correctly. no consideration, no contract. What do you mean by this? For a contract, consideration is one of the essential elements. Consideration இல்லனா contract இல்ல. அது உங்களுக்கு தெரியும். என்ன சார் எக்ஸாமுக்கு 20 days முன்னாடி should I come and teach you contractல consideration இல்லனா it's not valid? No, all of you know that. Yes. Okay. In that there are some exceptions that also I know. What are those exceptions? These are all those exceptions. Correct? Are you following, guys? These are all the exceptions. 1 2 3 4 5 6. What is the logic over here? I'll come to the logic. How do I remember this? Okay. What is the first thing you learnt as a kid? First thing you learnt as a kid when you're 2 years, 3 years old. Louder சொல்லுங்க. Online here, yes. First thing you learnt is love. First thing you learnt is ABCD. Correct? So you all learnt first thing in life is ABCD. Where you learnt? In school? First. School la kathukningla? Online. Where did you learn? Parents would have taught. Of course, in school, pre-KG, all of that. In LKG, you would have learnt. But even before that, your mother or father or grandparents or wherever you grew up, they would have taught you ABCD first. Because for LKG also interview, tell ABCD. Then they will teach you again after that. ABCD you should know. So, no contract, no consideration. Look at this. A, B, C, D. That's it. Okay. A is agency. B is bailment. C is charity and completed gift. D is time bar debt. Okay. Remember 4 points. Sir, no other points are there. No, sir. I'll tell you how. You learnt ABCD now in 2025 almost. Okay. 2025 or 2024 end, or you learnt when you were born that year in the past. Which year you learnt ABCD? 2008, when world was in recession, you were learning ABCD. Correct? Okay. So I learnt ABCD in 2008. So you learnt in the past. Who taught you? Did you give any money for parents to teach you ABCD? Why they taught you? Because your parents taught you ABCD in the past because they have natural love and affection to you. That time also they had, now also they have. Are you getting it, guys? So how to remember? No consideration, no contract in exam. ABCD, when I learnt in the past, I learned because of natural love and affection. That's it. Who will forget this? Are you getting it, guys? Online. So how to remember no consideration, no contract points? Quickly, guys. I learnt ABCD in the past out of natural love and affection. So no consideration, no contract. What is the mnemonic, guys? A, B, C, D. What is A? Agency. B, bailment. C, charity and completed gift. D, time bar debt. When you learnt ABCD in the past voluntarily, who taught you? Parents, out of natural love and affection. That's it. All points over. Are you getting it, guys? So, doctrine of privity of contract. Doctrine of privity of contract. Our mnemonic is triple A. That's it. Triple A. A is agency, acknowledgement, assignment. With this, you will get trust. With trust leads to marriage. Marriage leads to family settlement. Family settlement leads to covenants running with land. Here, no contract, no consideration, no consideration, no contract. That point. What is the mnemonic? ABCD. அவ்வளவுதான். ABCD. Agency, bailment, charity, completed gift, time bar debt. When I learnt ABCD in the past, out of natural love and affection. That's it. Are you able to remember all the points, guys? Okay. Clear? Fine. Then we also have one more concept. My agenda of this class is not to teach you the concepts directly, but indirectly through questions. So first let us get to these questions. Don't worry, guys. I will share the soft copy with all of you. If you are still yet to get it, I will share it, guys. Don't worry about that. for now follow. Okay. Now unit 2 consideration. I'm taking only case law based questions. Sir, why you have only in this material only 5 questions for this? See, September 2024 RTP is also there. We have even 2019 past paper. Why only 5 questions are there? I am having only case study based questions. Why I am discussing only case study based questions? 2025 exam, most questions are what? Case study. I don't want to make this PDF bigger by adding a question. What are the exceptions to doctrine of privity of contract? Direct questions are not there in this PDF. I'm also not going to discuss because you know how to write. Are you following, guys? Clear? Okay, online, any doubts, anytime. Don't think sir is taking class and all. In the chat, put your doubt, I will see it. If it's immediate, just unmute and talk, guys. That's it. If you unmute and talk, it's more than enough. We'll start off. Let's read the question. I hope it's readable, guys, for you. Visible online, okay. You can read it by yourself, but I will also read. Yes, okay. Sohanlal sold 10 acres of his agriculture land to Mohanlal. Okay. On 25th September 2020 for 25 lakhs. Land is sold for 25 lakhs. Property mentioned, the papers mentioned a condition among other details that whosoever purchases the land is free to use 9 acres as per his choice, but remaining 1 acre has to be used by Mr. Chotlal, son of seller, for carrying out farming activities. What is happening so far? Sohanlal sold land to Mohanlal. How many acres of land? 10 acres. In that he told, in 9 acres, Mohanlal, do whatever you want. You build a mall, you build a hospital, you build a school, you build apartment, you don't build anything, that's your wish. But 1 acre in that 10 acres, even though you purchased, it's your land, you should allow that for Mr. Chotlal, my son. Sohanlal's son is Chotlal. Allow my son to do what work, guys? Farming. What emotion. See, this land 10 acres, my full family is doing farming. Unfortunately, now we are not able to continue. So 1 acre, allow him to do farming. That itself is the condition of sale. Otherwise, I'm telling Mohanlal, don't buy. Okay. Next, on 12th October, when the sale took place, 25th September, correctly after sale, on 12th October, Sohanlal died, leaving behind a son and life. On 15th October, now the purchaser, Mohanlal, all these he was silent because Sohanlal is alive. Now that Sohanlal died, the purchaser, Mohanlal started construction of an auditorium of the whole 10 acres and denied any land to the son. Can you see, guys? Are you following? Okay. Now Mr. Chotelal wants to file a case against the purchaser. Can he file a case? The contract here is between whom, guys? The contract here is between Sohanlal and Mohanlal. But doctrine of privity of contract has some exceptions, which says what? Which says what? A third party can sue if the exceptions are met. What are the exceptions? AAA. In that, one of the points is covenant running with land. What is covenant running with land? If there is any condition attached to that land, then the third party can sue the person who's not following those conditions. Here the third party is Chotelal or Chotelal, whatever. Are you following, guys? Understanding? Now this answer when you're writing in exam, will you write all the exceptions? Now this answer which we just have here, this answer is a 5-mark question in exam or a 4-mark question in exam. Will you write all the other exceptions, assignment agency? You can write, waste your time. What can I do? Will you get marks? No. Presentation we will do today also. I will give you one of the questions. You will write the answer. I will again come and read your answers. I will take the image, put it here, discuss with all of you. The next 4 to 5 days, daily one question we will all write together and improve our presentation. Okay, fine. So look at the answer. I already discussed this in class, but for me the most important thing is presentation. I noticed in September students are not able to pass because of, okay, I will come to that. We will finish the questions. So look at this. Provision of the act is first given, then the analysis, and then conclusion. That's how I've given you the material also. Are you all following, guys? All of you with me? Hello. In the given problem, Mr. Sohanlal has entered into a contract with Mohanlal, but Mr. Chotelal has not given any consideration. The consideration did flow from Sohanlal to Mohanlal on behalf of Chotelal, and such consideration from third party is sufficient to ensure the promise. This is analysis. I will discuss this not now, when we are doing presentation discussion. Okay. Let's finish the next set of questions. Balwant, an old man, registered a gift of deed, granted certain land property to Miss Rima, his daughter. By terms of the deed, it was stipulated an annuity of 20,000 should be paid every year. Okay. Next, should be paid every year to Mr. Savant. Okay. Who was the brother of Balwant? Let's document all the facts, guys. First we have Balwant. When this question came, RTP November 2018. After that, it never came in any of the exams. Who knows? You could be the lucky ones. Old man, by a registered deed of gift. That means in writing and registered, granted certain land property to Miss Rima, his daughter. To his daughter, he is giving land, guys. By the terms of the deed, it was stipulated that annuity of 20,000 should be paid every year to Savant, who was the brother of Balwant. So what is happening? Balwant gave land to his daughter whose name is, but in this land he also gave a condition that Rima should pay 20,000 rupees to the brother of Balwant. What is his name? Savant or some fellow. Okay. Who was the brother of Balwant. Now what is happening? On the same day, Rima made a promise to Savant and executed in his favor an agreement to give effect of the stipulation. Okay, they entered into an agreement. Miss Rima failed to pay the stipulated sum. As usual, Rima did not pay. Otherwise, how a question will come? Yeah, someone should not pay. In an action against her by Savant, she contended that since Savant had not furnished any consideration, he has no right of action. They are saying the Savant cannot claim any money. Can Savant claim money or no? Yes. Savant claim here. Can Savant claim the money, brother? Yes. Contract is between whom? Balwant and Rima, two parties, but Savant, even though he is third party, he can claim. How? In case of what case? Which exception will come? In doctrine of privity of contract. I can bring in multiple exceptions here. One, I can bring in covenants running with the land again. Condition attached to the land in this gift that you have to make the payment. I can also bring family settlement. In the family, dana, daughter, brother. In the family settlement, the daughter was asked to make payment. So I can bring both of that. Which concept did they use here? Okay. Yeah, same concept only here. A stranger to the contract cannot enforce the contract, but stranger to consideration can enforce the same. So they used definition. Bhavant has entered into a contract. Samant has not given any consideration. Rima consideration did flow from Balwan to Rima, and such consideration from third party is sufficient to enforce the promise. Okay, here the concept they are using here is, in rules of consideration there will be a point called consideration can flow from the promisee or any other third party. We can use this. You can also use doctrine of privity of contract exceptions. See, for some questions you are allowed to use multiple provisions. How we are learning so far, answer everything in common sense, we will connect with provision. So here you can use exceptions of doctrine of privity of contract also, or the other concept used here is what? Consideration can flow from whom, guys? Third party, promisee or third party. Yeah, it is sufficient. Consideration can go from third party also. Are you following, guys? Anybody has a doubt? Otherwise we can go to next question. Anyone? Doubt? Yes, online. Can somebody read question number 3 for me instead of me reading it? Online fellows, somebody read question number 3 for me. Hello. Whoever reads first will get a chocolate. Yes, please ask the doubt. Got it, got it. I will give you. So online doubt is, if how can I apply two concepts? Priya, you will be seeing this more in the future. Okay. More in the future meaning, the more you get into CA interlaw, CA final, one concept will have multiple answers. Okay. See, it is like to cook biryani, is there only one recipe? You have many. Like that, for one answer, you will have multiple provisions sometimes, and sometimes you will have even provision from different acts. Okay. Let me give an example to understand this, and then I will tell you how to present also. Sir, I did, let's say, I did an offense. First in Nungambakam police station, they came and arrested me. I was there in jail for 2 days, I got home. Then again from Besan Nagar police station, they're coming and arresting me. Then again from Anna Nagar police station, they're coming and arresting me. Can I get offense 3 times for the same mistake? Can I be arrested 3 times? Sir, simple. I am driving without license. I got caught in signal. I paid 5,000 fine. Again, next signal. Again they caught me. Will I pay 5,000? What I will tell? Hey, just now I paid. Let me go home and get the license. Adukule thirpi pursana eppadi? So, you cannot be punished multiple times for the same offense. But if you repeat the offense, you will be punished. But here, when there are multiple concepts that you can write, you can give reference to both the concepts in the answer. And you can use the word alternatively, the above principle also can be applied. So when you have doubt, this concept or that concept or both can come. Write one provision, alternatively the other provision, analyze, conclusion. Are you following, guys? But sometimes you will know which is more strongly, which is more stronger. Here they are talking about consideration from can flow from third party, so we are going with that. But you can very much go with the other concept also. I hope your doubt is clear online. Yeah, can you read question number 3? Yes. Okay. Okay, I will teach you the concept with this question. Question Anana, Y gave loan of 30 lakhs to G for, and the loan became time barred. After time barred debt, G agreed to settle the full amount to Y. First of all, what is time barred debt? Promising to pay after. So let's say Vijay Mallya has taken 5,000 crores loan from, let's say, State Bank of India. Now, 10 years over, he is yet to repay. Can I say this is time bar debt? No. Time bar debt now, according to law of limitation, I'm going to give you a time period now, but this time period will change state by state. Some states it's 5 years, some states it's 6 years, many states it is 3 years. Don't have to remember, because the provision is changing state by state. Exam is written in India by full all students. So here what they're trying to say, follow very carefully guys. According to Limitation Act, if you don't repay for 3 years, the debt becomes time barred. Vijay Mallya didn't repay for 10 years, no. Is the debt time barred? No, he still has to pay. The logic of time barred debt is, for 3 years, SBI did not send any notice or reminder to Vijay Mallya. Every month SBI will send a notice. So imagine, I'll give a simple example. Sir, in my school, there was one friend, daily canteen he will take 10 rupees from me, or she will take 10 rupees from me. Somebody is there like that. Sir, I am the one who used to collect. So in school days, you used to take 10 rupees from your friend every day for eating some bhaji, samosa. Okay. You never repaid. It's been, let's say, 3 years malaichu. Your friend also never asked you now. Now after 5 years, you both met at a marriage. He's saying, hey, those days how much money you took from me? Give it back to me. Give me 500 rupees now. Will you pay? No. As per law, that debt has become time barred because he never asked you for 3 years. That means if any loan is taken and not asked for 3 years or more, it becomes barred by time, so it's called time bar. But here what is happening in this question, after the time bar debt, G agreed to settle the full amount to Y. Now look at this beautiful concept here, G and Y. G and Y. Now initially Y paid to G how much? 30 lakhs. 30 lakhs. And G was supposed to repay. G did not repay. Therefore, this full contract has become time barred debt. In a contract, you will get something, you will give something. Correct? Here, Y is giving 30 lakhs and from G will later give back how much? 30 lakhs plus interest. That means I am giving something, I will get back something. So what is the core logic of time barred debt? If you see in time barred debt, this old contract is no more valid. Now the new contract, G is repaying how much? 30 lakhs to Y. But what is G getting? Nothing. This is the first contract A. This is the second contract B, where he is repaying now. So what I am saying, follow very carefully. Look at this. The first contract A that you can see here is no more valid. Now how can G repay 30 lakhs? Okay, he will repay. Y is getting something. What is G going to get? Nothing. A contract means there should be consideration for both the parties. Huh? That is why exception says time barred debt is valid even though one party is not getting any consideration. Here G is not getting any consideration even though he is repaying. நான் சொல்றது புரியுதா லாஜிக்? ஐ எம் ட்ரைங் டு டெல் யூ லாஜிக். எதுக்கு சார் டைம் பார்ட் டெப்ட் ஒரு எக்ஸெப்ஷனாக இருக்குது? ஏன்னா நேச்சுரல் லவ் அண்ட் அஃபெக்ஷன் உனக்கு புரியும், சேரிட்டி உனக்கு புரியும். எதுக்கு டைம் பார்ட் டெப்ட் ஒரு எக்ஸெப்ஷன்னா, பழைய கான்ட்ராக்ட் காலி, இப்போ புதுசாக என்டர் பண்ணுற கான்ட்ராக்டில் இங்கே G 30 lakhs மட்டும்தான் தரான். அவனுக்கு என்ன வருது? ஒன்றுமே வரல. பட் ஒரு கான்ட்ராக்டில் போத் த பார்ட்டி ஷுட் கெட் சம்திங், தட் இஸ் மிஸ்ஸிங். தட்ஸ் வை திஸ் எக்ஸெப்ஷன். If you see all the exceptions, one party will not be getting anything. Charity, I'm only giving. Completed gift, I'm only giving. Are you following, guys? Understood? So in this case, promise to pay time bar debt is still valid even though there is no consent. How to write this? No, these questions can come in exam for 3 marks. 3 marks, 3 points. Look how beautifully they have presented, guys. Look how they have presented over here. Where there is an agreement made in writing signed by debtor or agent to pay wholly time bar debt, agreement is valid even though there is no consideration. First 2 lines concept. Next I'm writing facts. In the given case, loan given by Y to G has become time barred. This dabba is facts. This dabba is my facts. Next line. Thereafter, G agreed to make full payment to Y. Second line is analysis. Not even analysis actually. It is again facts only. Here this fully is facts. No marks for this. Now look at the analysis and conclusion. Referring to the above provisions of Indian Contract Act, contract entered between 2 parties post time bar debt is valid. Therefore, G is bound to pay the money to Y even though it is time barred, condition is fulfilled. Are you understanding, guys? First I am saying what is time barred. Then I am saying in my question there is a time barred debt. Therefore, time barred debt is valid in solran. Purida. That's it. Presentation, don't complicate things. Keep it simple. Are you following, guys? That's it. Next, last 2 more questions and then we'll be done with this. Concept based questions. Let me do 5th and then we'll come to 4. 4 is one of your latest RTPs. RTP September 2024. 5th one. Okay. So I've taken all the case study based questions in last 6 years. From this chapter I'm saying. Okay. Sham, aged 58 years, almost getting close to 60, was employed in government department. He was going to retire after 2 years. Very good. They made a proposal to Sham to apply for voluntary retirement from his post so that Dev can be appointed in his place. Dev offered a sum of 10 lakhs as consideration to Sham to induce him to retire. What is happening here? I am in a job. My age is 58. I still have 2 more years. Let's say from online we will take, let's say, video is lagging or is video clear, guys? Is the video lagging or it's clear?
Clear, sir.
Okay. Clear, okay. Let's say we'll take online, let's say Priya is there or we'll take someone Ram over here. What you guys did, you offered me 10 lakhs. Sir, you please retire. Even though you have 2 years, you retire now. If I retire now, you can come and join. Are you getting it? Sham refused at first instance, but when he evaluated the amount as consideration, it's double of his cumulative remuneration to be received in 2 years. He agreed to receive the consideration and he took the money. Whether this agreement is valid, I'll give you a classic example. How many of you saw Pushpa 2? Straight up, 1, 2, 3, online. Sir, put in the chat, sir, I saw Pushpa 2. Online, one student told not clear. It's clear for majority, then it should be your internet. Okay. Some of you saw Pushpa 2. In that there will be one scene where Allu Arjun in the first half of the movie, those who have not seen, don't worry guys, see after exam, it will come in OTT. Or if you are planning to see now also, see, I will not say don't see and all. In first half, he will give money to police. So police will retire from job. Sir, spoiler la onnu kadiyadu. Okay. He will give money, so police will retire from job. Okay. That is the same example here. Somebody is giving money, so I can retire, so they can get the job. What is the answer? Is this, you tell me in common sense. Sir, I don't know Indian Contract Act. Leave it. I don't know what is RTP September 2024. Go home. Ask your parents this question. Ask them, is this valid? What is it valid, guys? No. Edukku Contract Act? I'm always keep telling guys, law is all about common sense. I can answer this even if I skip the chapter because it's common sense. But what is important, which provision I will write. For that you should study. Your parents will tell, hey, this is not valid. But they can't tell you which act, which provision. That you should connect. Which provision is this in consideration? In rules of consideration, one of the last rules says consideration should not be unlawful, immoral or against public policy. So here consideration is legality of consideration, that consideration should not be unlawful. If the consideration is unlawful, such a contract becomes void. That's it. Are you following, guys? You can also write from unit 3 one point called traffic in relation to public offenses. I can bring the point, traffic in relation to public offenses is against public policy. Even though it's unit 3, why the question is over here? Relates to consideration. This point is there in unit 2 also. So I have just put it over here. Fine. Last question. Question number 4. Look how many times it came. It came in RTP once, MTP once, again in RTP. Yet to come in main exam. That means it's waiting to enter the exam. First, Ramlal Birla was a big businessman of city of Pune. Okay, Ramlal Birla, na Aditya Birla it could be. Pune, same. Having 2 sons and 1 married daughter. He decided to gift 1 house to his daughter, and for this purpose he called his lawyer at his house and made a written agreement for such gift. I think question which came, yeah. The lawyer advised him to get the transfer document properly registered. When they both were going for registration of document, they met with an accident and both of them died. Later his daughter found the document and claimed the house on base of document. Explain if she can get the house as gift under Indian Contract Act. Why it's coming in this chapter also, gift and okay. Can she get the document as a gift? We would have discussed 2 sons, avanga dhaan plan pannirpaanga. Okay. Can she get the document as gift? No. Why? Certain documents have to be registered, then only it has validity. You can't write the concept of no contract, no consideration, but gift is an exception. No, sir. Gift is not exception. Completed gift only is exception. Yes, Birla wanted to give gift, but he was not able to give the gift because the document was still not registered. Only when you register, the gift is transferred. Are you following, guys? Second part of question. Sham Mundra, a big businessman having, I think same question. 1 son and married, he decided to give house to daughter. Same question, guys. Same question. What is the provision they are writing? Provides agreement made without consideration is valid if it is in writing, registered under the law for the time being in force, and the document is made on account of natural love and affection between parties in near relationship. That is the provision. But here they cannot claim. Look at this. In the instant case, look at the question, answer is smaller. Look how they wrote. First I am writing the provision. Whatever is the provision, I will write that. Next, in the instant case, the transfer of house made by Ramlal Birla on account of natural love and affection between the parties standing in near relationship is written but not registered. So I am saying in the above points, natural love and affection is covered. Document is written. That also is covered. They are in near relationship. That also is covered. But what is not covered? Not registered. That means above provision not applicable. Therefore, conclusion. Hence, the transfer is not enforceable. Daughter cannot get the gift. It's very easy, guys. Write the provision, write the facts, connect that with the provision. That's my analysis. Conclusion. Are you following, guys? All of you with me, guys? Online, any doubts? With this, we are done with unit 2. Consideration chapter. Online. All of you clear? Type a yes if you have any doubts. Let me know. Perfect. Okay. So again, I'm repeating for benefit of everybody. What are the questions we are discussing in class? From May 2018 to September 2024. That's the previous attempt. All case law questions from RTP, MTP, past exam and book back la only case study questions. Sorry, we are going to discuss for all the acts. With that case law, we are revising the concepts wherever relevant and focusing on presentation. Before we go for break, I want all of you to write answer. Okay, I will give you two questions. You will write answer for any of those two. One, either write answer for question number 4 or or question number 1. 1 or 4, hard to present both. I will send you the soft copy, guys. Either 1 or 4, first one or fourth one, you will write the answer. After the break, we will resume. Today, thankfully, no technical issues. I purchased Apple Mac for the class. சரியா வேலை செய்ய மாட்டேங்குது. Some 20,000 rupees Windows PC is working, guys. That's why all this thing. But from now, rest of the classes, I will just continue in the same setup. I'll try to figure out what happened in that. Okay, fine. We'll go for break. Now it's almost 9:50. What time do you want to resume?
Sir,
Yes, online.
sir, do we have to also write the facts of the case, sir?
Okay, coming to presentation, since we have some new students today for the class, we're going to discuss fully. Facts of the case don't write on top because there is no mark. Provision, analysis, conclusion. Today I will again repeat the process. After break, don't worry, we will spend half an hour in presentation. You all know what to do. I will tell you, you have to mail your answer sheet. How I'm going to give you feedback, okay? I will give a mail ID here, okay? Which ID to send? Okay, I will just give a mail ID in the chat, guys. You just write the answer and mail the answer to this email ID right now. Whoever is going to mail the answer, I will take your answers, put it in the image over here, and I will discuss. Whosoever answer reaches me, because of I'm giving you time for answer, we will resume at 10:30. I'm giving you 40 minutes break. 10 minutes to write the answer, 30 minutes for break. I've given the email ID also. You all know that. You will send to that. In subject of the mail, write your name. Name எழுதி அனுப்புங்க guys. Okay, fine. I have sent the mail ID in chat. Have you guys received it online? Google Meet receive பண்ணீங்களா? And the other one. Hope all of you received it, guys. Yeah, just send it to that. Just the image. I will see you all post break 10:30. Thank you. Just stay in the call. Don't have to leave. Same link. No change. It will just become dummy for some time. Okay. I'll correct this over here. Just a minute. Just give me a minute, guys. I'm just downloading this. One, two, just three more left. PDF அமிச்சிட்டாங்களா? again PDF. Okay. Online, is it visible, guys?
Yes, sir.
Okay, let's start the revision of Unit 3 of Indian Contract Act, other essential elements of a valid contract. Our revision is going to be more question focused. You all know from 2018 till 2024, all the case study questions of ICA we are going to discuss one by one together. We will practice them. Okay. Here, quickly concepts if you know, this chapter talks about four essential elements. You know the essential elements of a valid contract, which includes two or more parties, offer and acceptance, and many other things. In that, four essential elements are capacity to enter into a contract, free consent, lawful object and lawful consideration, agreement not expressly declared as void. Exactly these four concepts you have to learn. I will just give a 5 minutes revision of this chapter. I am not going to spend more time. Capacity to enter into a contract means who is capable to enter into a contract. Everybody except these people, instead of major, let me write here minor. When the provision comes, I will explain the provision, guys. So minor can't enter into a contract. Sound mind can, the opposite, unsound mind cannot enter into a contract, and somebody who is disqualified by law cannot enter into contract. That means who can actually enter into contract, whatever is given over here: major, sound mind, not disqualified by law. Have you ever thought why minor can't enter into contract? Why? Sir, I am in class 12. I am 17 years old. Yeah, I have maturity, sir. Why can't I enter into contract? Why are you stopping me by keeping age limit 18? Why? No, because law says, correct. Why? Because law says that. Why does the law say for minor like that? Anybody? They can have the capacity to think lawfully. Let's say you go to a 10-year kid and give one chocolate, he will go. Correct? Or a 12-year-old kid, if you induce them with what they like, they are more susceptible to go for that. You can easily convince kids. Okay, depends each kid. PlayStation I will buy and give. Sir, no sir, chocolate I will buy PlayStation. Two iPhones if I buy and give, you will sign whatever I ask you to sign. So the law believes that after a certain age, you get the maturity to think by yourself, for yourself, and take decisions for yourself. Sir, I have a friend, sir. His age is 22. Still, he doesn't have maturity, sir. Like a kid, he will keep fighting. Yeah, somebody even today could be 35. they will still keep fighting. அதுக்காக I can't tell matured people can enter into contract, immature people should not enter into contract. அது எப்படி define பண்ணுவேன்? How will I test maturity? So the law has just said, okay, around 18 years most of you finish school. Around 18 years most of you finish your education in class 12, and you will enter either a professional course like CA where you are, or you will join college. Mostly at 18 years you would be in class 12 or college first year, or maybe college second year. That's it. So you are done with your school life and entering the real world. So law believes at this age you have the maturity. That's it. That's why they fix the number 18. Beyond this, no more logic. Free consent, you know what is free consent, guys? Contract where the consent of the party is free. They will say free consent is not there if any of these five are present. Coercion, section number 15, undue influence 16, fraud, misrepresentation 18, mistake is 19, if I write. Quickly, what are each of these points? Coercion, I am threatening you with a physical threat, showing the gun, scaring you with physical threat. I will harm you, or I'm kidnapping, I'm going to kidnap you. That kind of pressure is there, means that's called what? Coercion, doing any activity. Undue influence, what is that? More using the position I have, more of a mental pressure. Imagine I am setting the ICAA foundation paper, law. I'm not setting this example, solran. Okay. Now I'm saying, okay, all of you watching online here, everybody, give me 10,000 rupees, or I will tell all of you have a smartphone. Huh? Sell that smartphone to me for 100 rupees. I will buy from all of you for 100 rupees. Then if I can buy it from you for 100, question paper la 20 marks I will reveal to you. Undue influence, using the position I have to take and influence you to get advantage. Let's say same thing, you are having a phone OnePlus. Yes, what phone do you have? Redmi. I'm telling her I will buy this Redmi phone for 2 lakhs. Come on, sell it to me. Is this undue influence? How? I'm asking you to sell your Redmi phone. You don't want to sell it. You like that phone. I'm saying here, take cash. In my bag, I have 2 lakhs. 1 lakhs. Don't take it, guys. Okay. 2 lakhs I will give you. Give me the Redmi phone. I will reveal the question paper to you. Can I say this is undue influence? Yes or no? No. This is not undue influence. In undue influence, when I influence you for a decision, I should be getting some advantage. And you should be at a disadvantage. Buying your Redmi phone for 2 lakhs, who's at advantage? You. Correct? You can buy 2 iPhones, or you can buy 10 Redmi phones. Enak that disadvantage, buying your Redmi phone for 2 lakhs. Unless there is some confidential information, some movie script, or some, let's say, some copyright music is there. I'm talking about the phone as such. Are you getting it, guys? Fraud, I don't have to teach you. You know better than me. Doing an act with an intention to cheat the other person. That's it. I am doing something தெரிஞ்சுதான் சார் பண்றேன். அவன் அடி வாங்குவான் சார். I'm going to do it intentionally. I want to cheat the other person. That is fraud. Okay, you have many examples. Misrepresentation is what? Let me give an example. You wanted to buy, let's say, a bike. So you went to a second hand showroom. You asked the shopkeeper, this bike, what is the mileage? He told the mileage is 40 kilometers per liter. But actual is only 30 kilometers. Actual is only 30 kilometers. I know it's 30. தெரியும்டா எனக்கு தெரியும்டா 30. I know it. But simply, intentionally, I want the sale to be done. So I am telling 40 so that you will buy. You went to Pothys to buy a shirt or to buy a dress. You wanted pure cotton. That fellow knows it's only 50% cotton. But he's telling you, sir, ma'am, look at this. Pure cotton. It came from Kanchipuram. It came from here. Or it came from Delhi. Pure cotton. I know it's not cotton. But in that label also I am putting 100% cotton and selling it. What is that? Fraud. Now 30 kilometers the bike goes, but I am telling you what, 40, I think it is 40, I don't know, it's 30. According to me it is 30, sorry, according to me it is 40. I don't want to cheat you, but I think it is 40, so I told you it is 40 and you purchased. Is this fraud? My intention was not to deceive you, my intention is not to cheat you. Examiner, you should not write cheat. How to get marks? Deceive. Write the word deceive. Are you getting? My intention is not to deceive you. I believed it to be true. Shopkeeper in Pothis is saying, sir, this is 100% cotton. Shopkeeper does not know that's not true. Because according to shopkeeper, he got the goods at the label என்ன இருக்கு 100% cotton. So shopkeeper thought what? It's cotton and he sold it. So you can't blame the shopkeeper. You can only blame the shop. The shopkeeper did misrepresentation, but அவனுக்கு தெரியல. இப்போதான் ஜாயின் பண்ணியிருக்கான் புதுசா. Only if he works for 2 months he will know, oh, this is fraud. Okay. Are you getting it, guys? What is mistake? Now I wrote section 19 here for mistake. That is not correct. 22 is mistake. Now in the section 19 I wrote here, sir, I wrote section 19 so that you all learn section 19 and fail in the exam. I am a sadist. I am a sadist teacher. I want you all to fail. That's why I wrote section 19. Fraud. I did fraud. I wrote section 19. I thought it was 19 is correct. Misrepresentation. Now ஒண்ணுமே யோசிக்கல, சும்மா ஃப்ளோல 15 16 17 18 19 அப்படி எழுதிட்டே போனேன். I didn't even know. I thought it's, I mean, I just thought, then it becomes a mistake. Are you following, guys? I had a doubt. I had a doubt if it is 19, but still I wrote it. It's a mistake. Are you following, guys? Clear? Understanding the difference between all these five? I'm sure regular class la I will take this for 4 to 5 hours. Whole chapter சொல்றேன். Chapter 3. Full chapter will go for 4 hours. Okay. In depth we will go for each concept. But if I do, I mean, we don't have 100 hours here. That's why I'm revising in marathon speed, brushing the concepts for you guys. The belief is you already know this. Okay. Last third one, lawful object and lawful. Do things on a lawful manner. Sir, I'm conducting class here, sir. Behind me, we are selling drugs. The class suma. You're all sitting under the ground floor. There is one drug factory. Summa class and solely we are doing class. The main money comes from that. Summa I'm saying. Example. Now, I am paying rent for this classroom 1 lakh for this premises and down one premises is there. Is this lawful activity? No. Anything you do which is against law, see, I will tell you there are 2 ways to earn money. Okay. Now, I will just educate you on one thing. By dealing in drugs or any kind of illegal activities, you can earn 3 times more money. But will you do that? No. There is something called ethics. Same way, the law says illegal activity, anything illegal according to law, you can earn money, but don't come to me if you get trouble in that. Are you following, guys? Let's say because of doing some illegal activity, kidnap, I did kidnap, sir. That person did not pay the money. I kidnapped somebody, then I returned their son or daughter. They gave me a suitcase with cash. After opening suitcase, cash was there, but fake money. That I found only after 1 week. Can I go to court and tell, oh, I didn't get the money? போலாம் court, திருப்பி வர முடியாது. Okay. Are you following, guys? So anything lawful object and lawful consideration doing against the Indian law, it is not valid. Agreements expressly declared as, அங்க ஒரு 10 பாயிண்ட் கொடுத்திருக்கான். Bilateral mistake, agreement in restraint of trade, agreement in restraint of marriage. All these are what? Expressly declared as void. When those points come, I'll explain, guys. We have more points here, like wagering agreement is one. Meaning should be certain. There are about 10 points. Remind me once we finish the questions. I will come and revise those. points towards, then I'll revise now itself. Now itself, then we'll go to questions. Let's go to those 10 points. Yeah, agreements expressly declared as void. I already told you. What did I tell you? Made by incompetent parties. Who is incompetent? Minor. If minor makes an agreement, it's not valid. That I anyway know. Again, the law is coming back in section number 11 and confirming that this is void. Agreement made under bilateral mistake of fact. Both parties made mistake. What mistake? Let's say I booked one Uber auto. Okay. Look at this. I wanted to book Uber auto. I wanted to go from Royapeta, Chennai to Ananagar, Chennai. But in the app, I put wrong location. Okay, I put wrong location. Instead of Royapeta, I put Nungambakam, Chennai. The auto driver Anna also, instead of coming to the location that is there, he went to some other place. So I also made mistake. He also made mistake. Agreement becomes void. Okay. Agreement where the consideration or object is unlawful. Just now I told. I am paying consideration from earning in drugs. Unlawful. I am doing illegal activities. Like, let's say kidnap. Object is unlawful. It is void. Agreement consideration is unlawful in parts. Then also it is void. What is unlawful in parts? Let's say this classroom la I am paying 1 lakh rent. One half we are having class. Other half I am dealing in drugs. I am paying only 1 lakh rent, but this rent is for two things, lawful and unlawful activities. Lawful and unlawful. So the lawful part, the classroom becomes valid. The unlawful part, dealing in drugs, becomes void. Are you getting it, guys? Next, agreement in restraint of marriage. Sir, what is this? Let's say Aishwarya Rai is getting married to whom? Already married. What getting married? Getting married, already married to whom? Hello? Correct only, no? Hello? Fine. Any change happened? Huh? I'm not updated about it. It's correct. I hope this is correct as of 2024. Okay. Now, let's say when they got married 15 years back or 10 years back, Salman Khan entered into a contract with your name, Ayman. Okay. Salman Khan entered into a contract with Ayman. What is the contract about? Salman Khan is saying, Ayman, I will give you 100 crores. You have only one task. Stop this marriage. ஏதாவது பண்ணுப்பா பாம்பை போடு கரண்ட் ஆஃப் பண்ணு ஆர் ஏதாவது பண்ணு நீ the marriage should stop 100 crores I give you can't do with 100 crores but you have to stop the marriage but Salman Khan பண்ணான்னு தெரியக்கூடாது it should be a secret. Now agreement in restraint of marriage is void but it is valid if who's getting married is not Aishwarya Rai, not Abhishek Bachchan. Let's say one minor, I don't want to name any minor here, guys. Minor is getting married to a major or minor is getting married to a minor. Okay. Whether it is with consent or without consent, according to law, minor marriage today is not valid. Now Salman Khan is saying, I am the hero. Ayman, come on, let's go together and stop this marriage in the 100 crores. படம் எடுக்கலாம் வாங்க நான் காப்பாற்றும் போது you shoot. Okay. This contract is valid because you are trying to stop something which is not valid. Are you following, guys? Understanding? That's it. Agreement and restraint of trade. Every human being has the right to do any lawful business. Sir, Sangeeta restaurant is there. Next to Sangeeta, I will open Sarana Bhavan. Next to Sarana Bhavan, I will open Ratna Cafe. Next to Ratna Cafe, I will open something else, Akshayam, whatever. That's fine. So what? All of them are in the same line. Competition irukkum. You can't enter into agreement to stop someone from doing business. If you do like that, it becomes But however, this has some exception. In case of partnership where goodwill is transferred, see, exception is more logical. Sir, 10 years, for 10 years, Sangeeta restaurant is operating here with partner A, B, and C. Now, suddenly C leaves and starts here one more branch called Geetam. Not fair, no. Of course, it's not fair, correct? Because number 10 varshama we have earned one brand, you will simply start one Geetam and take all the business and cheat me. So if you can have reasonable restrictions, you can have what, guys? Reasonable restrictions. Sir, then what happened in reality between Sangeeta and Geetam? They failed to have an agreement. They did not have agreement. So I don't know exactly what the issue is, but from what I have heard, the partners had some fight. So some partners split and started Geetam, others continued with Sangeeta. But if they had it in writing properly, these people could not start Geetam. It's not valid. Because as per Contract Act, you can have agreement in restraint of trade is void. But what is valid, guys? Reasonable restriction is valid. They could have made a contract between them. If at all we leave in the future, nearby 5 kilometers, you should not start the same branch or similar food business. அவங்க அது பண்ணல. They believed each other. Trust. Okay. So that issue came. That's it. Are you following, guys? But still, whether Geetam or Sangeeta, both are earning in crores. Correct? We are only paying 150 rupees for dosa. Correct? Agreement and restraint of legal proceedings. We saw that, yes. We saw that in detail in class also. Here, quick revision. Agreement and restraint of legal proceedings. What is that? If, let's say, CSK versus Dhoni, and Dhoni, they have an agreement that tomorrow if CSK and Dhoni fight, CSK should not file a case against Dhoni, Dhoni should not file a case against CSK. அப்படின்னு ஒரு அக்ரிமெண்ட் போட்டாங்கன்னா அக்ரிமெண்ட் இஸ் நாட் வேலிட். Going to court is every human's right as per Constitution of India. Constitution of India says it's my basic right to seek remedy in court. That right cannot be removed. But for this, what is the exception? Agreement and restraint of legal proceedings exception is what? Instead of court, you can go for something called arbitration and cancellation. You can go for arbitration and cancellation. Agreement, the meaning of which is uncertain. Come on, give me 200 rupees. I will give you ice cream. How much ice cream? What flavor? What quantity? Matters. So meaning is not certain. Are you following, guys? Next. Agreements made without consideration. Just know we finished. Idan chapter 2. What is the exception here? ABCD. Agency, payment, charity, completed gift, time bar debt, past voluntary service, natural love and affection. Now are you able to recollect the points with ABCD easily, guys? That's it. Agreement to do impossible act. You know, guys. Summa solluvan. Sir, in 1 week I will get 6-pack. எப்படி வரும்? Whatever you do, you can't get 6-pack in 1 week. I'm not Kamal Haasan in Indian 2 to get whenever I want 6-pack. Okay, va? So agreement to do impossible acts, it becomes void. Then wagering agreements. You know what is wager? Wager is important because there are a lot of sub points and important for Jan 25, not tested for a long time. What is wager? What is not wager? Transactions which are similar to wager. Those 4 points are there. That race horse prize, mark that as important. Now we'll get into questions. I have done a quick, I think 10-15 minute revision of the chapter in marathon speed, guys, because most of the time I want to spend in questions and presentation only. Online, are you all there, guys? Are you all following? Hello? Hello? Can I get a confirmation from you in chat or unmute? Are you all there, guys? Hello? Yes. Yesterday night I was working in the house. Usually I work late. I work till 12, 1, 2. Earlier I used to work till 5, 6 a.m. directly. But now I've reduced it. Trying to sleep before 12. It will take time. I can't suddenly one day. For last 10 years I'm somebody who used to be awake all my night and work. Now I'm trying to sleep before 12. Before 12 I'll plan it will become 1, 1:32, I know. So I have a studio room in the house. I was working yesterday. Night 11, 11:30, my brother was there. He said, I'm going to order ice cream and so on. I said, okay, fine, order. Then I was sitting in the room and working. I thought, till the ice cream comes, I will work. Then I will finish, eat ice cream and sleep. That was the plan. Not healthy, don't do that. Okay. Then suddenly when I was in the room, hall வந்து சிரிச்சுனே இருக்கான் அவன் ஃபுல்லா full half an hour is laughing. Then I came out. My wife, my son, everybody were there. Then I asked, why is he laughing so much? Then my wife said, he's watching Indian 2. அதே ஹாஃப் அன் ஹவர் சீன் திருப்பி திருப்பி போட்டு அவன் சிரிச்சுனே இருக்கான், அவன் தாங்க முடியல சிரிப்பு அப்படின்னு. ஓகே ஓகே, ஐம் yet to see the movie. Then I sat and saw for 1 hour. Then I understood why he was laughing. So whenever you are stressed out, I think you can watch this movie called Indian 2. ஜாலியாக இருக்கும். They might be crying over there, but you will laugh. Okay. It's actually a comedy movie, guys. பார்த்தீங்களா? Anybody saw that? Okay. That time I couldn't see in theater, but miss பண்ணிட்டேன். தியேட்டரில் பார்த்தா ஜாலியாக இருந்திருக்கும். Okay. Fine. Let's get to questions. No offense to any Indian 2 fans here. Anybody? Sir, I'm இல்லையா யாருமே இல்லையா? Online anybody? Don't record and put this reel. Okay. Fine. We will start off. This time I'm going to ask you all to read. So students are going to read. I will just discuss the answer. First, we will have someone online to read. Yes, who's going to read online? Whoever unmutes first. Whoever reads first will pass in Jan 25.
He approached Mr. Chotu and offered to sell his motor car or 3 lakhs. Mr. Samant told Mr. Chotu that the motor car is running at a rate of 30 kilometers per liter of petrol. Both the fuel meter and the speed meter of the car were working perfectly. Mr. Chotu agreed with the proposal of Mr. Samant and took the delivery of the car by paying 3 lakhs to Mr. Samant. After 10 days, Mr. Chotu came back with the car and stated that the claim made by Mr. Samant regarding the fuel efficiency was not correct, and therefore there was a case of misrepresentation. Referring to the provisions of the Indian Contract Act 1872, decide and write whether Mr. Chotu can rescind the contract in the above grounds.
Answer, guys. Take a minute, go through. Samant owned a motor car. He approached Chotu and offered to sell his motor car for 3 lakhs. Samant told Chotu, car is running at 30 kilometers. Both the fuel and are working perfectly. Test பண்ணாங்களா? இல்ல. Samant சும்மா சொல்றான். Okay. Chotu agreed with the proposal and took delivery. Now, what is the answer, guys? Is this misrepresentation or fraud? Depends on the case. அந்த அஜித் படத்தில் சொல்லுவானே ஒரு மெலிசான கோடு இந்த பக்கம் அந்த பக்கம்னு சொல்லி அந்த மாதிரி here also misrepresentation and fraud, it's a very thin line of difference. Meaning இதே question, if Samant did it with intention to deceive, it becomes fraud. Samant did not do with intention to deceive. He just told believing that to be true. Then it becomes misrepresentation. Here, from the facts in the question, is there anything regarding misrepresentation? Yes. Now, these are the kind of questions where you need to take the assumption. So you will write both in provision. Look at this. As per section 19 of Indian Contract Act, where consent to an agreement is caused by coercion, fraud or misrepresentation, agreement of contract is voidable at the option of party it was so affected. Okay. I'm writing the full provision, guys. First I'm writing, if there is coercion, fraud or misrepresentation, then it is voidable. Exception, if such consent was caused by misrepresentation or by silence by fraudulent within the meaning, then it is not voidable. who had the means of discovering the truth with ordinary diligence. There is one concept which says the buyer should have tested it. Okay. In the given situation, both the fuel meter and speed meter of the car were working perfectly. Okay, here they are not saying, they are saying it has already been working perfectly. Chotu had the means of discovering the truth with ordinary diligence. Therefore, the contract is not voidable. Why? Which is the key word? After 10 days. Yeah. So, if you see here, first I cannot talk about fraud here because nowhere question is saying Samant wanted to deceive the person. Adilla. It could be misrepresentation, it can be misrepresentation, but the buyer Chotu did not take any sufficient care. Here we are referring to the provision of this one, the exception. Contract is not voidable if party whose consent has had the means of discovering the truth with ordinary diligence. You should have checked one time you took the car for one round, you could have found out. So that is why he cannot claim any damages. Very similar question we have. Next question we will see. Have you all understood this? This is the source. It came in so many times in the past. It's there in study mat, MTP November 18, 2019 and May 2020. 3 RTPs it has come and 1 MTP. Okay. Anybody has a doubt here? Online. See, if you guys have doubts, just immediately unmute. Whoever is watching online, I'm giving you the full power. I don't want only 1 or 2 students to unmute and ask doubts. If you have doubts, put in the chat. Don't send me direct message. Direct chat, no, I will not be able to read. Okay. In the everyone chat option, just send it to me. We have so many students online. Okay. Fine. No doubts. Now we'll proceed. Next question. Yes, who's going to read first? Whoever reads first will get the chance to read, guys. Once someone starts reading, don't ask if I can read. Yes, start off. Tirpi solnu. Yeah, go ahead. Go ahead, Hasana. Hasana, go ahead. Yes.
Ishan, aged 16 years, was studying in an engineering college. On 1st March 2018, he took a loan of 2 lakhs from Vishal for the payment of his college fee and agreed to pay by 30th May 2019. Ishan possesses assets worth 15 lakhs. On the due date, Ishan fails to pay back the loan to Vishal. Vishal now wants to recover the loan from Ishan out of his assets. Decide whether Vishal would succeed referring to the provisions of the Indian Contract Act 1870.
Answer. Will he succeed? What happened? Ishan, aged 16, minor, studying in engineering college. How, sir? How, sir? 16 years I'm studying in engineering college. That should not be the question. Okay. Double promotion he got. Okay. On 1st March, he took a loan of 2 lakhs from Vishal for payment of college fee and agreed to pay back by 30th May. Ishan possesses assets worth 15 lakhs at age 16. Okay. On due date, Ishan fails to pay back the loan. Vishal now wants to recover the loan from Ishan out of his assets. Can he recover, guys? Yes. Because the loan is taken for necessity. Minor exception. Whenever loan is taken for necessity, you can't sue the minor. You can sue the personal assets of minor. For example, let's say here we have Priya. Priya took loan of 2 lakhs. She's not repaying. I can't sue her. I can't put Priya in jail. But Priya has a phone. Priya is coming in bike, sir. Are you following, guys? Their personal assets I can take. That bike should be in Priya's name. It's in my mother or father's name. I can't take. Personal property. No, உன் பேர்ல என்ன இருக்கு? Phone உண்டு தானே? Phone வாங்கும்போது யார் பேர் கொடுத்தீங்க பில்ல? Your name only. So it's yours. I can take it. You are wearing watch, huh? That's mine. Personal assets. Are you following, guys? Clear? Look at the answer. According to section 11, a contract majority is important. Again, look how they have written. Minor, you can't enter. Therefore, minor is not personally liable. Okay. That's it. You will read the answers. You anyway have the soft copy. All of you got this, guys, online also. Did you get the soft copy of questions? Can you confirm?
Yes, sir.
Okay, that's it. So you have the answers. You can read for presentation. Okay. Next question. Let me read this quickly. Yeah, go ahead. Who is reading that?
Sir, I have one doubt, sir.
Yeah, please ask the doubt.
Sir, why it can't be wide ammunition?
Why it can't be void ab initio? Previous question number 2.
Yes, sir.
Okay, simple. Follow, guys. Contract with a minor. Contract with a minor is void ab initio only. It is void ab initio. But this has a few exceptions. Okay, in the work. This has a few exceptions. In that exception only, if minor enter into a contract for purpose of necessity, then personal property can be used. Sir, but what is this necessity? Sir, I am buying iPhone, necessity. Redmi phone, necessity. Smartphone today is a necessity for studying. Laptop, necessity. What is necessity? Now, without that, I can't live, sir. Food, phone, correct? Without phone, can you live today? Can you throw the phone for next 1 month? Hello? Yes, okay. Fine. Oh, இப்போ தான் second question முடிச்சிருக்கோமா? Okay. We'll do a few 10-15 panni. We'll go for a kutty break. But fast. Next question number 3. I hope Kirtika online your doubt is sorted.
Yes, sir.
Yeah.
Thank you, sir.
Okay. Okay. Next. P sells by auction to Q a horse which is known to be unsound. The horse appears to be sound, but P knows about the unsoundness of the fraud. I know horse is mental, but still I'm selling the horse. Is this contract valid in the following circumstances? If P says nothing about the unsoundness of horse of X, is this valid, guys? No, it is fraud, and valid. If P says nothing about the unsoundness, I am P, I am selling the horse to you, I know it is unsound, but still I am not telling that to you. Silence, fraud. Are you getting it, guys? I am selling this pen to you. I know it's not writing, but I'm still selling it to you, saying, "Hey, samaya eldu vechukonga." Purila. No, see, ordinary, let the buyer beware, but when I'm buying the horse, how I will know horse is unsound? Normally I will check, okay, horse movada illiyan solli. If I want to, let's say I'm selling a table to you. In table I stuck a 50% off sticker. When you're buying the table, you will see, oh, everything is nice. After coming home, you will remove the sticker. Sticker remove பண்ணும்போது அது கீழே crack இருக்கு. So to hide the sticker, hide the crack, I put sticker. If somebody is doing fraud, they will conceal the defect. So here, he knows about it, but he did not tell. So look at the answer. Okay. The contract is valid as per section 17. Mere signs as to act likely to affect the willingness of person entered into contract is not fraud. Here it is not the duty of seller to disclose the defects. Contract is valid, but it can become voidable at the option of Q. Are you following? Second, if P says nothing about it to Q, who is P's daughter who has just come of age? Question Purila, what is the question? P sells by auction to Q, the horse appears to be sound, okay. If P says nothing about it to Q, who is P's daughter who has, okay, Q is daughter of, Q is daughter of P. What is the answer, guys? Not valid. Why it's not valid? Fiduciary relationship. See, when I tell you something is, let's say, for example, when I teach you a concept, or let's take a different example. Let's say in school, your accounts teacher in class 11, they would have taught you your first journal entry, or whenever you learn the first journal entry, you trust that. If they tell something is debit now, you will take debit. You won't question back. You won't apply ordinary diligence over there. So basically, in case of fiduciary relationship, so this question is basically testing which concept, fraud and silence and exceptions. If we go quickly read those points in the book, yeah. So normally, whether silence amounts to fraud, hello, answer is no. But this has some exceptions. Silence is fraud in the following situations. It is the duty of the person to speak. Same question. Look at this. A, by auction, knowing it is unsound, he says nothing about the unsoundness of the horse. This is not fraud by A. You are right. So here the person B should have asked some question. If he asked question, if B asked the question, is the horse okay? Then if A was silent, then it is fraud. I'll give a simple example. You went to a shop, you purchased, let's say, one pen. Okay. You didn't check if it is writing. Whose fault it is? My fault. But I asked the shopkeeper, pen is fine, is it writing properly? Shopkeeper told, yes, pen is fine. But actually it's not fine. Then it becomes fraud. When silence is equal to speech, I'm asking you something. Hey, is the pen fine? You are remaining silent. That means I will think it is speech. Then few other cases, like, what are the exceptions? What are the exceptions? And the marriage, fiduciary relationship, where are those points? No, no, in the example, I'm talking about other exceptions. Exception to silence amounts to fraud. And the contract of fiduciary relationship, contract of insurance, ஞாபகம் இருக்கா? இல்ல இல்ல, not under influence. In certain cases, nope, I'm talking about contract of insurance, marriage brokerage contracts. Or it's okay, it is basically silence is equal to speech. Under this, there are some more exceptions. No, nothing is there, huh? It should be there. Why it's not there? Yes, Priya.
Page number. The relationship of which is guru and his disciple is considered as a fiduciary relationship or no, sir?
Page number?
No, sir. It's 1.66. Because I read in BCom it is a fiduciary relationship, so this I was just having a doubt in that.
Okay, okay. No, it is not just that one. Okay, I think it is now removed in the book. 2.76, huh? இது வந்து வேற இது. Okay, leave that point, guys. Okay, leave it. Fine. We are talking about where fraud is equal to silence. Okay, now are you clear with point A and B? That's it. I tried to find. I think it's removed from the book. Fine, then leave it. If Q says to P, if you do not deny it, I shall assume the horses sound. P says nothing. This is fraud, because this is a case where silence amounts to fraud. The contract is not valid since silence is equal to speech and hence amounts to. I asked you to talk, but you did not talk. Clear, guys? Okay. Next, question 4. Quickly, X816 borrowed loan of 50,000 for his personal purpose. Few months later, he had become major and could not pay the amount. The lender wants to file a suit against X. Can he file? Now that point will come. Any contract entered as a minor is void ab initio. If this loan is not for personal purpose, like let's say it is for necessity, then you can sue. Personal property, personal purpose. What X did with this 50,000? He went to Goa and came. That means all of you, when you were minors, you could have taken loan and escaped. உங்களுக்கு அப்ப தெரியுமா? தெரியல. Now you can't do anything about it. Okay. That's why they didn't teach this in school. Okay. Fine. So look at the provision, guys. First provision presentation I'm talking about. I've given the answer with the headings. Provision, write about the full concept. Minor, it is void ab initio. Look at this, it is void ab initio. However, necessity supplied is enforceable. Necessities means those things essential. They cannot include luxury or unnecessary costly things. Facts. The borrower minor at the time of taking the loan, therefore the agreement is void ab initio. This is not necessity, therefore the person cannot file a suit. It is not enforceable by law. Clear, guys? Okay. Question number 5. Yes, we will have someone to read that online. Online Priya has a doubt. Does the relationship of religious guru and disciple are fiduciary relationship? Yes. Next.
Shruti, a minor, falsely representing her age, enters into an agreement with an authorized laptop dealer, Mr. Gupta, owner of SP Laptops, for purchase of laptops on credit amounting 60,000. For purchasing a laptop on 1st August 2021, she promised to pay back the outstanding amount with the interest at 16% per annum by 31st July 2022. She told him that in case she won't be able to pay the outstanding amount, her father, Mr. Ram, will pay back on her behalf. After 1 year, when Shruti was asked to pay the outstanding amount with interest, she refused to pay the amount and told the owner that she is a minor and now he cannot recover a single penny from her. She will be adult on 1st January 2024. Only after that agreement can be ratified. Explain by which of the following way Mr. Gupta will succeed in recovering the outstanding amount with reference to the Indian Contract Act 1872. By filing a case against Shruti, a minor, for recovering of outstanding amount with interest. By filing a case against Mr. Ram, father of Shruti, for recovering the outstanding amount. By filing a case against Shruti, a minor, for recovering of outstanding amount after she attains the majority.
Superb. This question came in May 2022 in exam and in RTP December. First, basically minor took a loan, guys, not for personal purpose, buying laptop. The word personal kudukla, so I can't assume that. Can you recover money from minor with interest? No. Contract with minor is void ab initio. So therefore, the person who filed the case, Gupta gali na unnume varadu. First, Gupta will not succeed in recovering this. Second, by filing a case against Ram, father of Srishti, can you recover? No. Minor cannot bind parents, meaning I can't go to Apple store when I'm 15 years and tell, give me iPhone. I will buy the iPhone. Then later, I will tell my father will pay. Go ask my father. Father சொல்லுவான், எனக்கடா தெரியும். You should ask me. Minor cannot bind the guardian or parents. Third, by filing a case against Srishti, a minor, for recovery outstanding after she attains maturity, after she becomes major, can you do it, guys? Guys, yes or no? No, because you cannot ratify a contract after becoming major. So no ratification after majority. Minor cannot bind parents. Then Gupta cannot sue. Understood, guys? Yes, doubt. question they have given where she told that she won't be able to pay, her father Ram will pay back on her behalf. She should not tell that. Father should tell. Father should tell, I will take responsibility. I am the guardian. Then yes. If you actually see, minor, there are some 15 exceptions. What minor can do, what minor cannot do. In book, I should mug up this. What minor can do, what minor cannot do. Correct? Tell me a few points. I will again tell you shortcut how to learn. How in consideration chapter I gave you a mnemonic, triple A, ABCD. Here also very easy. These 15 points we will summarize, guys. What minor can do. Minor is very important. Why? In full 100 marks, at least one question related to minor will come. Either from unit 3, what minor can do, what minor cannot do, or from partnership act, minor as a partner, or can minor be partner in LLP? Tell us, sir. Not there in syllabus, no, sir. They will ask. Can minor be a shareholder in company? This is there here itself. No, you can't be a shareholder of a company. But minor can be partner in partnership firm as a beneficial partner. What about LLP? Can minor be a partner in LLP? No. Shareholder of company, LLP also, he can't be a partner. Are you following, guys? Clear? Because for LLP you have to enter into a contract. Minor can't enter into a contract. Can you tell me more points? What is there here? Minor and no? Yeah. Minor cannot. No. Ratification. Then minor cannot plead minority. Correct? He can plead minority. Correct? ஐயோ நான் மைனர் பா என்ன விட்டுருங்க ஒன்றுமே தெரியாது அப்படின்னு சொல்லலாம் மைனர் ஓகே நெக்ஸ்ட் here minor is liable for necessity. Then just see the points here, guys. You should tell contract is void arbitration. Minor can be an agent. Perfect. You have agency in your syllabus. Minor can be an agent. Okay, next. He can enter into benefits of contract. Next.
No insolvency.
Yeah, can plead minority, liable for necessities, contract by guardian, no specific performance. Correct? No insolvency, cannot be insolvent. Next. Like this we will summarize, guys. I'm doing for a few cases. Partnership, yes, no insolvency. Minor can be agent. Cannot bind parent or guardian. Cannot bind parents or guardian. But he can enter into joint contract. Then you can enter into a contract if you have a surety irunda, you can enter into a contract. Okay, I will write point here 1b. If there is a surety, you can enter into a contract. Next. Liability for torts. He is also liable for fine. Are you following, guys? Okay. You have to mug up all these points. What minor can do, what minor cannot do, we have summarized. Day before exam, nobody can go through the book like this. You should have by now summarized your full book into your notebook. Your notebook is the asset. Okay. I'm not doing it for all the concepts, but wherever it's possible, we are doing it. Okay. I can summarize this whole thing in just one concept. Minor can do everything where he is not liable. Law is drafted like that. Don't make the minor liable. That's why he can be partner in a partnership firm only for profits. He will not share loss. Correct? Admitted to benefits as partnership. Surety is there, na, he can enter. What surety? My father is there as surety. I can enter into any contract. Plead minority. You can incur liability, but you can, you are a minor, you are escape. Liable for necessity, one exception. Apart from this, minor is not liable for anything else. Correct? You can be an agent. Why? I am not liable. Who's liable? Principal is liable. You can enter into benefits of a contract. I don't have liability, only benefits. No specific performance. See, only if there is specific performance, minor is saying, I will take money and come and dance in one show. He's not coming and dancing. You can't sue him. You can't make them liable for any act, monetary or non-monetary. Joint contract he can enter. Oh, no specific, in the பக்கம் வந்துரும். No specific performance. Here let me write the point of torts. Okay. What is tort? Civil wrong. அதான் bookல இருக்கு sir. Civil wrong. What is civil wrong? Minor is liable for tort. Civil wrong now. Meaning you are playing cricket. You hit the ball. Neighbor's window broke. Can you tell? I am a minor. I will not pay you. வந்து மண்டையிலே அடிப்பான். Correct? Now, are you following, guys? You took a bike. I am a minor. Full speed you went. Crashed one tata. Gone. Can I tell? I am a minor. Don't arrest me. Yes, a minor is not liable for criminal offense. If a minor does a kidnap and tells, I am a minor, please leave me, give the money to me. Tort na, you are liable for civil wrong na. If you make a mistake as a minor, like breaking the window of your neighbor or any accident, you won't be arrested, but you are still liable to pay the penalty for that glass. You or someone should pay for you. Are you following, guys? So now can I summarize very easily? Everything that is there in can do are cases where minor is not liable. Everything which is cannot do, there is a chance for you to become liable. If you are shareholder of company, liability to pay call money. If your LLP partner, limited liability is there. No ratification, because if I can ratify, then you will become liable after becoming major. Cannot be insolvent. Liable ஆக முடியாது. எப்படி insolvent ஆகும்? Cannot bind parents or guardian. Just know we saw question. I can't simply tell my parents they will pay unless they tell. No specific performance, which I just explained. Are you following, guys? Understood how we are summarizing? I'm not discussing all concepts, but some important areas I will discuss like this. Okay. Next, quickly let's do a few questions, guys. Question number 6. Yes, we will do this fast and then go for a short break. Yes, online we will have. Kirtika, can you read the next few questions? Kirtika, fast.
Father promised 1 lakh is first attempt. The son passed the examination in first attempt, but father failed to pay the amount as promised. Son files a suit for recovery of amount. State along with reasons whether son can recover the amount under Indian Contract Act 1870.
Can you recover, guys? Why? This is a social agreement. There is no intention to create a legal relationship. இந்த மாதிரி கொஷின்ஸ்லாம் வச்சு மோட்டிவேட் பண்ணுவோம் உங்களுக்கு ஐசிஐயில் எம்டிபி கொஷின் motivating you that time to study. Okay, next question number 7. Yes, Kirtika, read it fast. We'll do it fast now. Yeah.
Mr. X, a businessman, has been fighting a long-drawn litigation with Mr. Y, an industrialist. To support his legal campaign, he enlisted the service of Mr. C, a judicial officer, stating that the amount of rupees 10 lakhs would be paid to him if he does not take up the brief of Mr. Y. Mr. C agrees, but at the end of the litigation, Mr. X refuses to pay Mr. C. Decide whether Mr. C can recover the amount promised by Mr. X under the provisions of Indian Contract Act 1872.
Go through the question, give the answer. a businessman has been fighting a long drawn case with Mr. Y industrialist to support his legal campaign. He enlists the service of C judicial officer stating that 10 lakhs would be paid to him if he does not take up the brief of Y. I am paying the advocate judicial officer 10 lakhs so that you don't take up the case. Mr. Y of brief of Y, Mr. C agrees, but at the end of the litigation, X refuses to pay. I told you I will pay if you don't take up the case. You didn't take up the case, but I didn't pay. Decide whether C can recover the amount. Can he recover, guys? No. Because why? Agreement opposed to public policy. There also we have a story I will tell later. Okay. This section says all agreements are contracts made by free consent. Every agreement with object is unlawful. In opposed to public policy, you have some points. Stifling prosecution, then interference with the court of justice. Where is that point? Yeah. Seventh one, interference with courts of justice. If you, whose object is to induce any judicial officer, then the contract becomes void. This question, even if you don't know Indian Contract Act and if you ask your parents, they will tell not valid. It's common sense. We just have to connect with the right concept. Are you following, guys? Okay. So this comes on the same point, interference with the course of justice. Are you following, guys? Okay. Next, question 8. Read it, Kirtika, fast.
Mr. S, aged 58 years, was employed in a government department. He was going to retire after 2 years. Mr. D made a proposal to Mr. S to apply for voluntary retirement from his post so that Mr. D can be appointed in his place. Mr. D offered a sum of 10 lakhs as a consideration to Mr. S in order to induce him to retire. Mr. S refused at first instance, but when we evaluated the amount offered as consideration is just double cumulative remuneration to be received during the tenure of 2 years of employment. He agreed to receive the consideration and accepted the above agreement to receive money to retire from his office. Whether the above agreement is valid. Explained with reference to provisions of Indian Contract Act 1872.
Go through, guys, quickly. Is this valid? Sir, I don't know Indian Contract Act, sir. Leave it. What is the question saying? D can be appointed in his place. D offered 10 lakhs as consideration to induce him to retire. Bribe kuduthirukkan. I'm giving bribe to somebody. Is bribe allowed? But still it happens, sir. That's a question. So, that bribe only in law, I can't call it bribe. That bribe is called traffic relating to public offense, na lancham, bribe. Okay. So, look at the answer. Look, first provision is saying, agreement opposed to public policy, traffic relating to public offices is becoming unlawful, which is void in Kurtana. Correct? Second paragraph, in the given case, S, who was going to be retired after 2 years, was proposed by Mr. D to apply for voluntary retirement so he can be appointed. He gave 10 lakhs. He initially refused and later received money. Just the facts are rewritten. If you don't write facts also, it's fine. But you have to write the facts connecting to the provision. Here, conclusion. S promise for sale of the employment in public service is consideration to pay 10 lakhs. Therefore, the above provision of Indian law is unlawful because it is opposed to public policy. It is traffic relating to public office. So, conclusion la irkira facts it I am writing again and I am connecting this with the provision by saying this against public policy. Yes. No, see. Actually, I can merge both and write the facts giving the, what to say, consideration for the office is against public policy because it is traffic for public policy. In fact, I can make this more crisp. Instead of writing the facts, I can merge it with the conclusion and write it as once. But when you will do that 2-mark question, you will do like yours. Merge the provision, facts, conclusion into one paragraph. 3-mark, you will separate and keep it so that it looks more professional. Okay. Next, yes, read it, Kirtika.
Mr. Joy owns.
Sorry.
Mr.
Yeah.
Joy owned 2 flats in a building. He wanted to sell flat number 101 to Mr. Roy. Mr. Joy offered to sell his flat number 101 to Mr. Roy, but Mr. Roy thought that Mr. Joy wanted to sell that flat number 102 and said yes for the agreement. Considering the provisions of Indian Contract Act 1872, discuss the validity of such an agreement. Contract.
Answer. Is it valid, guys? Not valid because of there is a mistake of fact. And I can also give one more concept here, certainty of meaning, where that's the same point. Look at the wordings they've used. One of the essential elements of valid contract is free consent. Consent is willingness, all of that fine. Where 2 or more persons are said to give consent if it's in the same sense. Here there is no certainty of meaning because one wanted to sell 101, other thought it is 102 irka. Wanted to know it is 102. So that I can also write about mistake here. Are you following, guys? Now these are cases where you can write 2 answers. When you're confused, write both the provisions. Just write the word alternatively. The same can be answered as follows. Don't mix both the provisions. Don't write certainty of meaning and mistake of fact together in the same para. One para, then alternatively the below provision also can be applied and write the second para. Whenever you have doubt, write both the paras. Are you following, guys? Clear? Following? Oh, question. Oh, next question. Yeah.
A enters into a contract with B that A sells his house for 10 lakhs to B. Further, they both signed an agreement that if B uses the house for gambling purpose, then B shall pay A 50,000 for it. B agreed to this. However, after a year of sale, B started gambling business in that house. Can A claim 50,000 from B? Discuss the reference with reference to the provisions of Indian Contract Act.
Answer, guys. Now look at this. Sell house for 10 lakhs. Further, they both sign agreement. If house is used for gambling purpose, then he will pay extra 50,000 for it. B agreed to this. However, after a year of sale, B started gambling. Can A claim 50? No. Agreement where consideration is unlawful and object also is. So unlawful consideration, unlawful object. And they also talk about agreements opposed to public policy where consideration is unlawful in parts. Consideration is unlawful in parts. Are you following, guys? One part, remember I told the example, classroom, one place I'm dealing in drugs, one class is happening. Then the lawful part is valid, unlawful part is void. So look at this, where some part of the object is legal and other part is illegal. Question arises about the validity and enforceability of such. Then if you can divide, the lawful object is enforceable, unlawful part is void. Same way here, 10 lakhs becomes valid, 50,000 is illegal, therefore void. So house agreement is valid, gambling is not enforceable. What I'm trying to say, ஒரே அக்ரிமெண்ட் இல்லை ஒரே கான்ட்ராக்ட்ல நீங்க வேலிடும் அன்வேலிட் ஆக்டிவிட்டிஸ் பண்றீங்கன்னா அதை பிரிக்க முடியுமா சார்? பிரிச்சிட்டிங்கன்னா வேலிட் வில் பிகம் வேலிடு, அன்லாஃபுல் வில் பிகம் இல்லீகல், வாய்ட். ஆர் யூ கெட்டிங் இட்? தே ஆர் இன்செப்பரபிள். சார் இதே கிளாஸ் ரூம்ல மார்னிங் 7 to 1 கிளாஸ் சார், போஸ்ட் லஞ்ச் தான் கேமே ஸ்டார்ட் ஆகும். ஆஃப்டர் யூ ஆல் கோ ஹோம் we will put the different lights here and we will do other work. Different to separate. Then the whole transaction becomes void. I will again revise this concept. If you see, sir, in the same transaction, I am doing both legal and illegal activities. Clearly I can distinguish this. Then the legal part becomes valid. This will be not valid or void. Sir, this is not possible, sir. For me, the legal and illegal are together. The legal and illegal are together. I am not able to distinguish or separate. Either legal, either illegal. They are together. I can't differentiate. Then the whole thing becomes void. Are you getting it, guys? Okay. Interest against obligation, no. Interest against obligation is a different concept. So interest against obligation, now imagine I'm working in Zomato as an employee. My obligation is interested towards Zomato. Now what I'm doing, I'm getting Zomato's information and selling to Swiggy. This is interest against obligation. You're doing something against my obligation. My obligation is to teach you class. I'm coming here to class. During class, I'm selling, let's say, daily I'm selling some chips, samosa to students. I'm bringing one suitcase and selling you chips and samosa. This is interest against my obligation. Are you following? Okay. Question 11. Is this speed fine or can we speed up even further? Can we speed up or same speed is fine? Same speed. Online doubt they're asking. Conclusion, can we use the word alternatively? Now remember Priya and everybody else, this concept of alternative answer will come maybe out of 100 marks in 10 marks. Or 2 or 3 questions could be like that. You can give alternative conclusion if there are two opposite provisions in the same question. Like misrepresentation irka illaya therla. Then you can give two conclusions for the two provisions you wrote. You can't write one provision. உனக்கு ஆன்சர் டவுட்டா இருக்கு சார், ஸோ ஐ வில் ரைட் ஒன் கேஸ் பாசிபிள் ஒன் கேஸ் நாட் பாசிபிள், அப்படிதான் வேணும். ஆர் யூ ஃபாலோயிங் வாட் ஐம் சேயிங் கைஸ்? நான் சொல்றது புரியுதா? You can't write one provision where the question is clear, you can't give both answers because you are doubtful. Where there is a genuine doubt, write two alternate provisions and two alternate answer matching provision. Are you following, guys? Yes. Question 11, read it fast.
Chandan was suffering from some disease and was in a great pain. He went to Dr. Junjanwala, whose consultation fee was rupees 300. The doctor agreed to treat him, but on the condition that Chandan had to sign a promissory note of 5,000 payable to doctor. Chandan signed the promissory note and gave it to doctor. On recovering from disease, Chandan refused to honor the promissory note. State with reasons. Can doctor recover the amount of promissory note under provisions of Indian contract?
Is this a valid contract? See, I already paid consultation fees of 300. Why should I again pay 5,000 first? Now the contract for 5,000 is entered between the Chandan, who is patient, and the doctor Junjunwala because of the fiduciary relationship that they have. Therefore, such contract becomes voidable. Contract becomes what, guys? Voidable. Are you following? Next, question number 12. Quickly read it. Kirtika, yes.
Karan agreed to purchase wooden table for his study room from Mr. X. Table was in a good condition and was examined by Karan. Before purchasing, he found no defects in it and paid 20,000 for that table. Later on, it was found that one leg of the table is broken and Mr. X was pasted the wood and tried to hit the defects in the table. Can Karan return the table and claim amount back? Discuss the same with reference to Indian contract.
Go through the question, guys. Now that question comes, he was purchasing wooden table for study room. It was in good condition and examined by Karan before purchasing. That means buyer acted diligently. He did his duty. He found no defects and paid 20,000. Later on, it was found that one leg of the table is broken. Mr. X pasted the wood and tried to hide the defect in the table. What is this? Fraud. Can he claim the amount back? Yes. Section 17 says where when a contract is made to deceive the other party, this active concealment, other party intentionally conceals the material facts, then fraud is committed. Whenever fraud is committed, the contract becomes voidable at the option of aggrieved party. Therefore, here you will see in the case fraud is committed, the aggrieved party gets the right to rescind the contract. In present case, Current has examined the study table before purchasing. He could not find any defect as it was concealed. The word is important. It is concealed. Therefore, on the basis of above provision, he has suffered fraud. Can you see how presentation is different here, guys? We have given provision, analysis, conclusion. How many other totally questions? We have about 21, 22 questions. Okay. Next.
Sir,
Yes.
sir, if the salesman himself is a retailer, then he purchased he himself unknown that it is broken, then it is misrepresentation.
If salesman is a okay, so her question is, sir, in this Current purchased Mr. from X. Imagine the salesman did not know about this. Company la somebody else stuck the table and they kept. Salesman theriyama he told it's in good condition. Then it becomes misrepresentation by salesman, fraud by the shop. Both are different people. Got it? Next.
Then in that case, what will be the answer, sir?
In that case, still the contract is entered between whom? Buyer and seller. Who is the seller? Shop is the seller. I am the buyer. Only middleman is the salesman. So still I will have the right to recover the money because there is a defect. The seller has done he has done the fraud. Okay.
Okay, sir.
Next, question 13. Can you please read it?
Kapil went to a departmental store to purchase a steel pan. He asked the salesman about the area in departmental store where steel pans are kept. The salesman indicated in the area with instructions that with steel pans, other metal pans were also kept. Kapil wrongfully picked an aluminum pan in place of steel pan, and salesman watched but said nothing to Kapil. Kapil reached his house and found that the pan was not a steel pan but actually an aluminum pan. Kapil filed a suit against the departmental store for fraud. Discuss whether Kapil is eligible to file suit for fraud against departmental store under Indian Contract Act.
Go through, guys. I think answer only concept is there. They have not given the full answer in print. I will just get this rectified. But you go through the question and tell me, is this fraud or not? Answer, guys. What is the answer? Now that we don't have answer, you should tell me the answer. Is contract void? Look at this. Sir, an answer tell us, sir. Answer in common sense. Kapil went to departmental store for steel pan. He asked the salesman about the area in departmental store where steel pans are kept. Salesman indicated him the area with instructions that steel pans and other metal pans are also kept. So correctly I sent him to the area of steel pans and also other metal pans are kept. Kapil wrongfully picked an aluminium pan in place of whose mistake it is? Kapil's mistake. The buyer only made the mistake. The salesman watched but said nothing. Salesman was silent. Why should he say? Maybe he wanted aluminium pan. Only if Kapil asks the salesman, is this steel pan? Then if I am silent, then it's a problem. Kapil எதுவுமே கேட்கலையே. Kapil அவனா போய் ஒன்று எடுத்துக்கிட்டான். Imagine you go to supermarket. You are asking where is lace. He is saying அங்க இருக்கு sir chips. You went to buy lace. Instead of lace, you took Cheetos and Kurukure. And you came to billing counter. will salesman ask you why pa you didn't take lace? Kepana. Only if you ask him, cheetos kati, இது லேசான்னு கேட்டீங்கன்னா he will tell, கண்ணு தெரியலையா, இது not lace. So here the couple never asked anything. So salesman watched and said nothing, which is fair on salesman part. Couple reached this house and found that pan was not a steel pan, but it's an aluminium pan. It's fault of couple for not being diligent. Couple filed a suit against departmental store for fraud. இங்க என்ன பண்ணிருக்கான் departmental store fraud? ஏதாவது fraud பண்ணிருக்கானோ? He should file case on himself and study better. Okay. Whether couple was eligible to file case under Indian Contract Act? Answer is no. Now we are able to answer without the provision itself. Here what we should write, the answer, since it's not there in print, you will write section 17 plus section 19. Section 17 says fraud means any person who is deceiving the other person. Here there is no concept of fraud because section 19 says where the person is silent, silent does not amount to fraud. Are you following, guys? Silent does not amount to fraud unless you are asked to talk. Are you getting it? Same similar question we saw above also in the three cases. Are you following last row? ஆமா, அவன் கேட்டிருக்கான் இங்க ஸ்டீல் பேன் இருக்குன்னு. I also showed no, அங்கதான் இருக்குன்னு சொன்னேனே. கரெக்ட். நான் எப்படி அந்த ஏரியாவில் இருக்குன்னு சொல்றேன். கப்பில் என்ன பண்ணுவோம், கப்பில் வாங்கிட்டு he should again come and ask, இது ஸ்டீல் பேன் கன்ஃபார்ம் பண்ணிக்கணும்ல. இவங்காக தனியா ரூமை போட முடியும் ஸ்டீல் பேனுக்கு. ஐ எம் ஷோயிங் வேர் இஸ் அ ஸ்டீல் பேன் வித் அலுமினியம் பேன். எனி ஸ்டோர் யூ கோ, similar goods will be kept together. I can't keep dustbin or chair next to steel pan. I can only keep other pans. Correct? Are you following, guys? Okay. Next question 14. Yes.
Sir, if there exists fiduciary relationship, then the silence amount to fraud, no, sir.
If there is fiduciary relationship, yes. In fiduciary relationship where it is because of trust, na, it amounts to fraud. Yes. Silence amounts to fraud. No, answer is no, but exception is fiduciary relationship. Next. Correct, your doubt is right. Next, question number 14. Can you read it soon?
Yes. Rahul, a minor falsely representing his age, enters into an agreement with a shopkeeper for a loan amount for purchasing a laptop. He gave his expensive watch as a security and took a loan for rupees 40,000. He was very happy to get 40,000 and quickly went to the market and purchased a laptop worth 30,000. He happily spent the rest of the amount with his friends on a pleasure trip. Later on, Rahul realized that his watch was an expensive watch and he should not have given like this to the shopkeeper. So he went back to the shopkeeper and asked for his watch back. Also, he refused to repay the loan amount. The shopkeeper disagrees to this and files a case against a minor for recovery of loan amount. Can the shopkeeper succeed in recovering the loan amount under Indian Contract Act?
Go through, guys. Good question. Give me the answer. Answer, guys. Simple. Any,
Sir,
yes.
He cannot pay the 40,000, but he should return the laptop to shop.
Okay, I'll explain the question. There are three elements here. What are the three elements? First, loan. I have taken loan. Second, I gave laptop. And third, second, I gave watch. So there are three elements in this question with respect to the minor. First, minor took a loan of, then minor purchased, and minor also gave watch. Sir, what are the provisions? Very simple. Keep all the three separately first. Any contract with the minor is void ab initio, therefore contract is not valid. Minor, if he is not repaying the loan, nothing can be done. Watch should be returned back to the minor. Court will order for the watch to be returned back to the minor, but the loan is void ab initio. Coming to the laptop, according to Indian Contract Act, is this for a necessity? No. The loan kekran. Loan is not for necessity. He went for a pleasure trip with his friends. According to Indian Contract Act, laptop need not be returned. But the court will order because of tort, look at this. Although no action can be taken against the minor, any property on his position, court, it's not court will. Court can order him to return the same. Hence, in the present case, Rahul is not liable to repay 40 from shopkeeper, but he can be ordered from the court to return the laptop. Are you following, guys? Therefore, accordingly, he can be ordered fraudulent misrepresentation. He can be ordered to return the goods that he has obtained. That's it. Meaning, if you go to iPhone shop and tell, I am a major, I will pay loan tomorrow, you purchase iPhone, the shopkeeper cannot get money from me, but at least the phone has to be returned. Are you following, guys? Next. Question 15. Anybody has a doubt until here, please let me know in the chat. Yeah, put it in chat. Next question 15. Please read it soon, guys. We'll go fast. Let's try to finish next 5 questions in 10 minutes. Fast, read it. Kirtika.
Mr. Shekhar wants to sell his car. For this purpose, he appoints Mr. Nandan, a minor, as his agent. Mr. Shekhar instructs Mr. Nandan that a car should not be sold at the price less than 1 lakh. Mr. Nandan ignores the instruction of Mr. Shekhar and sells the car to Mr. Mazum for 80,000. Explain the legal position of contract under Indian Contract Act.
Good.
Whether Mr. Shekhar can
Yes. Continue reading. Yes.
Whether Mr. Shekhar can recover the loss of 20,000 from Mr. Nandan.
Yeah, go to the question, guys.
Sir, minor cannot bind the principal.
So what happened? Shekhar wants to sell his car. This is basically a mix of agency and Indian Contract Act. Actually, both belongs to the same act only. Shekhar wants to sell his car. For this purpose, he appoints Nadan, a minor, as his agent. Mr. Shekhar instructs Nadan that the car should not be sold at a price less than 1 lakh. Nadan ignores the instruction of Shekhar and sells the car to Masum for 80,000. Explain the legal position. Let us write down the facts, guys. So we have Shekhar, who is principal, who appointed agent. Who's that, guys? Sorry? Nandan, who is the agent. And Shekhar instructs Nadan it should not be sold for less than 1 lakh, but Nadan ignores and sells to Masum for 80,000. And he sold it for rupees 80,000. So what is happening here? Basically, the principal told the agent not to sell for less than 1 lakh, but the agent is a minor who sold it for 80,000. This concept is from Indian Contract Act. Minor can be an agent plus agency chapter. More concepts come from agency chapter here. Applying logic, minor is allowed to be an agent only because minor is not liable. Therefore, who becomes liable? Shekhar, the principal, only is liable. That's why minor can be agent. Here I sold for 80,000. I will collect the money and give it to principal. That remaining loss of 20,000 Is agent liable, guys? No. Why did you appoint a minor as an agent? It's your fault. Appointing as agents is valid, but you cannot recover the loss of 20,000. So first question, can Mukund recover the loss of, sorry, yeah. Can Shekhar recover the loss of 20k from Nadan? No. Can Shekhar recover the loss from Masum also? No, because Masum also purchased from the agent. The agent represents the principal. So if agent is entering into a transaction, it is equal as if principal is entering into the transaction. Therefore, Masum also will not pay the loss. That loss of 20,000, in the end, Mr. Shekhar only should bear it. Are you following, guys? Or second question also is very similar. We can leave that. Go to next one. Question number 16. Yes, we will have somebody else, not Kirtika, somebody else to read the question 16 fast. Fast. Any doubts? Clear? Yes, Samantha, read it.
Pradeep sells by option to Rakesh a horse which Pradeep knows to be unsound. The horse appears to be sound, but Pradeep knows about the unsoundness of the horse. Is his contract valid in the following circumstances?
Hold on, Samantha. I think same question we saw on top. Let's save time. You refer to the above question. Read the next question. Yes. 17.
Rahul induced Neeraj to buy his motorcycle, saying that it was in a very good condition. After taking the motorcycle, Neeraj complained that there were many defects in the motorcycle. Rahul proposed to get it repaired and promised to pay 45% of the cost of repair. After a few days, the motorcycle did not work at all. Now,
Neeraj wants to rescind the contract.
rescind the contract, besides giving reasons under the provisions of Indian Contract Act 1872.
Go through. Go through, guys. So Rahul induced Neeraj to buy his motorcycle, saying it's in a very good condition. After taking the motorcycle, Neeraj complained that there were many defects in the motorcycle. Rahul proposed to get it repaired and promised to pay 45% of cost of repairs. That means there is misrepresentation, and Rahul, the seller, also agreed for repairing with some expense. After a few days, motorcycle did not work at all. Can Neeraj rescind? Can he cancel the contract? Can he cancel, guys? Answer is no, because here who are the two parties that we have? Rahul and Neeraj. So I have Rahul, Neeraj. Okay. Rahul sold a good which there is misrepresentation. The contract is, of course, voidable by Neeraj. Neeraj has two options. He can exercise the contract right and rescind or cancel his rights, or he can continue, or he can claim. Only one thing I can do. Voidable contract na cancel பண்ணலாம், இல்ல damages claim பண்ணலாம், இல்லனா continue பண்ணலாம். What did Neeraj choose to do? He claimed that damage only was 45% of cost of. Now after claiming damages, again after a few days, again Neeraj is suffering issue. The minute you exercise your right under a voidable contract, the contract becomes valid after that. Here once you exercise damages, it's over. You can't go exercise your damage again. This time I'm taking damage, sir, next time I will cancel. No, not possible. Are you following, guys? Only one thing you can do. So here the answer is Aggrieved party loses the right to rescind the contract. Look at this. He will lose the right to rescind the contract after being aware of misrepresentation and taking a benefit under the contract. Since you have already taken the benefit in the contract in one way, you can't take the benefit again. Are you following, guys? Sir, you have suffered some loss because food in Sangeeta was not good. They gave you refund or they replaced the idli. You went and ate one plate of idli, 50 rupees. They gave you 2 pieces. Taste was not good. Either he will give you money back. He's saying, sir, please wait pananga, sir. I will give you two options. I will give you money back or I will give you idli again. You said, give me idli again. They gave you new idli. It was good this time. Now again, can you ask for refund? No, you already got one remedy. You can't ask again. Here already 45% of cost of repair is given as remedy. Are you getting it, guys? Next. Question 18. Quickly, guys. Last 4 questions we will finish. These are all past exam questions. November 22, June 23. Okay. Same order. Yes. Read it. Same student. Samantha, can you read it for us, please? Question 18.
Sir. 18 or 19, sir?
18.
X agrees to pay 1 lakh if Y kills Z. To pay Y, X borrows 1 lakh from W, who is also aware of the purpose of the loan. Y kills Z, but X refuses to pay. X also repay the loan to W. Explain the validity of the contract between X and Y, between X and W.
Okay, let's draw this. X agrees to pay Y 1 lakh. X is going to pay Y how much, guys? 1 lakh. If Y kills Z, okay, X agrees to pay Y 1 lakh. If Y kills, so Y has to kill Z, Z, okay. X borrows 1 lakh from W, is also aware of the purpose of the loan. X is borrowing rupees 1 lakh from W, who is aware of the loan. Explain between X and Y and X and W. So here we have two contracts. X and Y is contract 1. X and W is contract 2. Can you see it, guys? Okay. Now the contract between X and Y, I'm again writing between X and Y, the first contract is an illegal agreement because its agreement for murder is illegal. Now what is supporting this illegal agreement? X was able to pay 1 lakh because he borrowed 1 lakh from. The agreement which is supporting the illegal agreement is called collateral agreement. Anything which is collateral to an illegal agreement also is void. So collateral agreement also is void. So to summarize, collateral agreement, if it is collateral for something illegal, if it is collateral for something void agreement, meaning if this is the main agreement and this is the supporting agreement, follow very carefully, illegal agreement will always be, therefore its collateral will also become void. Agreements are of course, but collateral agreements to void agreements are valid. I hope you know this, guys. You know this concept. That concept has been tested in this question. This also actually belongs to chapter 1. I'm just taking photos, so I will just inform the team to make the rectification. Okay. Next, last 3 questions. Question 19, I will quickly read it, guys. A, employer induced this employee B to sell his one room flat to him at less than the market value to secure promotion. If you want promotion, I will sell it this. B sold the flat to A. Later on, B changed his mind and decided to sue A. What is the validity of the contract? What concept is this? Undue influence. I'm saying if you sell your house to me for low price, I will give you promotion. எனக்கு வேற ஆப்ஷனே இல்லை. So undue influence. Therefore, undue influence is voidable. The party can sue the other party. Agreed party can sue the what to say? Agreed or affected party can sue the other party who caused the undue influence. Question 20. Same question. 2 lakhs, 1 lakh 50. That agent, correct? Agent question. Buying a car, selling a car. Just now we saw, guys. 1 lakh, 2 lakhs and 1 lakh 50. Inga pathome. Okay. Sumasa. Okay, fine. This came in RTV December 23. Next. Question number 21, 22 we will be done. Let me take photo of this also. I'm just taking it because seeing and correcting these things. See, anyway, it's all part of syllabus. And sir, why I'm taking photo? Question 19. Later I will put it in first chapter. Sorry, question 18 I will put in the first chapter. Anyway, it's part of syllabus. 1, 2, 3 questions like this interchange. Don't bother much about it. Sir, that means only these questions have been tested in the past. Yes. I'm not sure if you are aware or not. Every attempt, I will give something called expected questions for exam. Can I expect the questions also to be from the same list? No, because your exam is going to be combination of two things. Past exam questions RTP and MTP plus upcoming new untested areas. Now this list what we are seeing and what we are solving here is past tested questions, but exam will have both combination of past, which we are anyway discussing, and I will give you a separate PDF for untested areas expected questions. So then this we are anyway covering in class. Untested areas la eppadi question irukum, inimel da question varum. That's why in the expected question I will give you the list of concepts which are yet to be tested. So you will read those new concepts yet to be tested plus past concept, both will readily it will come in exam. Combination of both. Maybe 60 marks could be past, 40 marks could be new. That's why expected question list will have both. This I will give in the end of our class after 1 week. Okay. Are you following, guys? Okay. For example, can you tell one concept which has not yet been tested here? Minor. Can he be a shareholder in a company? No. Minor can't be shareholder in company. You know that. Inga varla. Minor is liable for tort, but never tested in exam. Are you following? So it's not there in this list. Never tested in the last 5 years and 6 years. Maybe 2015 it's tested. I'm taking only last 6 years because before 2018 it was CPT. MCQ based question. It was not writing for law. Fine. Next question 21. 21. Yes, Kirtika or Samantha, anyone read it fast? Yes, hello. Both of you are not reading. We'll have somebody new. Can I have Hasana from online?
I, who is a minor, purchased 10 fancy coats for the wedding ceremony of his sister on credit from Miss Surjiwala and Sons. The cost of all coats was 80,000. Not even a single coat was a necessity. Ayush has asked a worth of 1 lakh. Messrs. Surjiwala and Sons filed a suit against Ayush for recovery of 80,000 out of his assets. Following the provisions of Indian Contract Act 1872, whether Ayush is liable to pay 80,000 to Messrs. Surjiwala and Sons.
Yes. Can he claim, guys? Can he claim it? No, because minor took a loan. Is it for necessity? Not even single quote is for necessity. Therefore, Surjiwala cannot claim 80,000 from Ayush. Are you following, guys? Next, question number 22, last one. With this, we are done with today consideration chapter unit 2 and unit 3 questions, both put together close to 30 questions we have discussed. Concepts also, few important concepts here and there we discussed along with the questions. Last one, yes, Hasana, read it again for us.
Chotu of 17 years has purchased a mobile of 25,000 for online classes from Mobile Sales Center on credit. On due date, he did not make the payment of mobile. Mobile Sales Center sued Chotu and his parents for the price of mobile. Chotu has 15,000 as his cash balance, but his father has enough money to pay the price of mobile. Who will be liable to pay the price of mobile under the provisions of Contract Act 18?
So he purchased the mobile, he did not make payment. Mobile sales center sued Chotu and his parents for price. Chotu has 15,000 as cash balance, but father has enough money. Will father make the payment? First of all, why did the mobile sales center sell to Chotu? Minor, correct? You can't enter into contract with minor is void ab initio. Unless it is for necessity, you can recover. Here they have not given if it is for necessity or not necessity. So you can take assumption. Look at this. Minor is not capable to enter into a contract. Contract with minor is void ab initio. A minor cannot be enforced to pay his liabilities. Parents are also not liable. Parents also are not liable. However, if it is for supply of necessities, then minor is not personally liable. Only his assets are liable. Now in this question, necessity or not necessity? Tell me. How? Where it's given? Online class 5 years back, not a necessity. Online class. But after COVID, it has become a necessity. Therefore, in the instant case, parents of Chotu are not liable. Chotu's assets are liable to make the payment of price. Hence, he can recover only 15,000 from the assets. Are you following, guys? Clear? With this, we are done with this chapter also of questions. We'll go for a short break, come back and do one more chapter. From now, what I will do, before the next class, I will give you a list of topics that we will do in the next class. So you can revise that concepts and come for tomorrow's class. Not now. Now we will go for break. After break, we will do some other unit in Indian Contract Act. Now the time is 12:54. We will come back at what time? What time, guys? First, hold on. I'll just end this session in recording. Okay, good morning, guys. Good morning. Online, can you just confirm if I am audible, visible for all of you? Just confirm in the chat, guys, if I'm audible, visible for all of you. Yes, yes, okay. Super. Okay. Fine. So today's agenda is going to be simple. We are going to focus on completing question answers along with concepts in reverse working for 2 chapters, Indian Contract Act today, unit 4, which is performance of a contract, and unit 5, which is breach of contract and remedies. Okay, simple. Once this gets over, we are done with all the units of Indian Contract Act except for indemnity and guarantee, bailment and pledge, agency, which are special contracts. So the old syllabus would have been done, the new syllabus part only is pending. Now let me give a simple example to give the smallest of introductions for these 2 chapters. Sir, what do you mean by small introduction? Let's say you went to Sony showroom to purchase one PlayStation 5. You made the payment, they did the delivery of the PlayStation 5. That means performance is done. If you don't make payment or if they don't do delivery properly, then it leads to a breach. Or payment also done, sir, delivery also done, sir. After delivery, product is having some damage or issue, then also it leads to breach, that you will claim subsequent damages. So basically, if you see, every contract, you guys know, you would have studied in the first chapter itself, is a promise. Is a promise. We call it as reciprocal promise because both the parties promise each other to perform a few things, correct? Both the parties promise each other to perform a few things. That is mandatory, we all know that also. Okay, any of that promise fails, it becomes a breach. How to perform that promise is performance of contract. That's it. So unit 4 introduction and how do you perform that contract, because previous units till unit 3 of Indian Contract Act you would have studied how a contract is valid, when how a contract can be created. Unit 4 says go perform that. Promise பண்ண மட்டும் போதாது, போய் perform பண்ணு. Unit 5 saying if you don't perform, what is the consequence? Breach of contract. I will not be spending time now again revising each concept here or here. First let me finish the question answers, then in reverse we will take those question concepts and come back and learn. Okay, online, I hope it's all clear. We'll start off with unit 4, performance of contract. This has about 20 questions. Once we finish unit 4, we will take a small break, then again come back, do breach of contract, and then I will revise concepts in the ending. Whichever concepts you are feeling challenging, you will let me know. Or 4 or 5 concepts you can let me know in the chat. Sir, these concepts I am not able to understand, sir. Other concepts are very easy. For example, breach of contract. I yesterday, okay, let's say breach of contract for you. General damage I'm understanding, special is little confusing. Then I'll give you detailed examples for that. Now straight away let's go to questions. Unit 4, performance of contract. X, Y and Z jointly borrowed 50,000 from A. Yes?
Sir, screen is zoomed too much, sir.
It is Google Meet issue actually. I will maybe give you the YouTube link. You can see in that also. Just hold on. Just 1 second. I will just send you the link for YouTube. Okay. Just 1 second. Sir, YouTube link comes, sir. Sir, actually, sir, இங்க பாத்தீங்கன்னா இங்க கரெக்டா இருக்கு சார். இந்த லிங்க்லயும் கரெக்டா இருக்கு, இங்க பாருங்க. இந்த ஐசிஐ லிங்க்கும் கரெக்டா இருக்கு. கூகுள் மீட் மட்டும் இப்படி இருக்கு. யூடியூப்லயும் ஃபுல்லா இருக்கு. ஏன்னு தெரியல அப்படி. ஸோ அது கூகுள் மீட் மட்டும் ஏதாவது வீடியோவில் ஏதாவது அவுட்புட். சார் ஓகே, இப்போ கரெக்டாக இருக்கு சார். Okay, it is sorted now, guys. For those who are watching online, YouTube or here, it's fine. Okay, fine. We'll start off. Sorry for the distraction in the first question itself. Let's go. X, Y and Z jointly borrowed 50k from A. The whole amount was repaid by A. repaid to A by Y. Decide in light of Indian Contract Act whether the following is possible. We are discussing which concept? Joint promisor. When there is joint promisor, question is silent. All the parties should bear the loss equally. If the party is not able to pay, then who will pay? If party is not able to pay, legal representative will pay. Legal representative also not able to pay, then the estate, whatever is there, nothing is available, sir. Then other party will suffer the loss. That's it. See, nobody is there to pay. For example, one concept here. I'm telling you concepts with questions. Here X, Y and Z borrowed from A how much? 50,000 in total. Imagine all three died. Legal representative also not there. Now who will pay? Nobody is there to pay. Then A will bear the full loss. That is the final consequence. Then I will just go to Tirupati and pray. Okay. Now in this question, let's go to question. Fully paid by Y. So question is, can Y recover the contribution from X and Z? Yes. What is per head share? 50,000 divided by 3. How much is coming? 50,000 divided by 3. How much is coming, guys? How much are you getting? 16,000? 16,667 can be recovered from each of the other parties. Next, legal representatives of X are liable in case of death of X. Yes. In case of death of X, legal representatives are liable. Can Y recover the contribution from the assets in case Z becomes insolvent? Yes. If Z becomes insolvent, you can recover from the personal assets to the extent available. That's it. Are you following, guys? That's it. The provision. First, you will write all the concepts of joint promisor. Section number, if you don't remember also, it's fine. All the concepts of joint promisor, na? First, they will pay equally. Look at this. First, they will pay joint and several equally. If it's not possible, then it will go to the legal representative. If that also not possible, you insolvent, it goes to estate. Same thing, 3 answers. Are you following, guys? Okay. Next. Like I said, just to revise, what all questions we are discussing from 2018 till 2024 September, all concept based questions. Why only 20 questions are no? Remaining questions that were tested in the past were direct question. What is joint promisor? Okay. Mr. Rich aspired to get a self-portrait made by an artist. He went to the workshop of Mr. C, an artist, and asked whether he could sketch the former's portrait on an oil painting. Mr. C agreed to the offer and asked 50,000 as full advance payment for the above creative work. C clarified that the painting shall be completed in 10 sittings and shall take 3 months. So, 10 vati I have to sit, look at you, I have to draw. Detailed self-portrait that is being done. Okay. On reaching the workshop for the 6th sitting, after half work is done, பாதி மூஞ்சிய draw பண்ணிருக்கான். Rich was informed that C became paralyzed and could not able to paint in the near future. C had a son K who was still pursuing his studies and had not taken up father's profession yet. In light of Indian Contract Act. Forget Indian Contract Act. Conceptually sollu guys. Conceptually solunga. Who is supposed to perform this contract? Mr. C, who is the painter. C is not able to perform. Can his son perform? In performance of contract, we have a concept called who will perform the contract. If the promisor is not able to perform the contract, we have other options like agent, legal representative, any other third person, or joint promisor. Correct? So if when will this come? Let's say you go to a marriage catering or painting my house. Painting the house is not going to be an extraordinarily personalized skill. So if I am not able to perform, my agent or legal representative or third person or joint promisor. But some cases, personal skill is involved. Sachin is playing for India. Sachin is injured. Can I put his son? Son can play. Mumbai Indians, he can play. That's it. Other teams, how we will play? So, same way over here, can Rich ask K to complete in his work for his father? No, not possible, because there is a personalized skill involved. For example, for wedding, I called, let's say, one chef, Venkatesh Bhatt. I paid Venkatesh Bhatt 5 crores. Who is Venkatesh Bhatt? I'm sure you will know. Comes on YouTube, Vijay TV, all of that. Okay. I called him for cooking. He told he will come and cook. Apana guest will be excited. No. The dosa podrana, everybody will go. So I'm paying 5 crores for him. He's saying he's having fever. Sorry, he can't come. He's sending his son. Will you agree? Will I agree? No. So when you're paying for one personalized skill of a person, only they can perform. Could Rich ask K for refund of money paid in advance for his father? Yes. Because contract cannot be performed. Yes, you can ask for refund. In the question, you don't have to know Indian Contract Act. If you just know what, guys, common sense, you will be able to answer. Correct? Next. But we have to connect with the provision. Same thing is given there. You will read the answer. You have the material. What you guys have to do, sir, for improving presentation. I'm sure I would have told this in class, but let me again re-insist on that. Any subject, CA, foundation, inter or final, I'm talking about descriptive, not MCQ. If you want to get good score, I always, not me, anybody will emphasize on these three things only. S stands for speed. Am I able to write for 100 marks in 3 hours? Sir, I wrote, sir, but handwriting e purile. Presentation is very bad. P is your presentation is what I keep telling under this 3 points. Write the provision, write the analysis along with facts, and then you write the, this should be crisp. It should not run for pages. Otherwise, speed adivangu. Sir, 100 marks elita, sir. Presentation also correct, sir. But conclusion, ellame wrong, sir. 0. You should be able to conclude accurately. Accuracy means what? For example, in this question, can Rich ask K to complete the artistic work? Answer is no. You are writing yes. Eppadi varum mark? Are you following, guys? So if these three things are correct, no chance you can get less marks. Look at this. Accuracy depends on your concepts. Presentation, we are working on it now. It depends, I'll tell you. And speed depends on how fast you write. For any subject, the way you learn is reverse. First learn accuracy. Any subject, accounts, law, in CA inter, tax, whatever. எது படிக்கணும் ஃபர்ஸ்ட் அக்யூரசி. எனக்கு ஆன்சர் கரெக்டா வருதா சார்? Am I able to give the correct conclusion? That means concepts only you should learn first. Be strong in the concepts. Once you are getting the answer accurately, slowly present. Write one answer in 20 minutes. It's okay. Focus on presentation. Even if I take 25 minutes for a sum, partnership, I am taking 1 hour for one sum, sir. Paravala. NPO, I am taking 1 hour. Paravala. Are you getting it accurately correct? And presentation is neat. So accuracy also is good. Presentation also is neat. Then you start focusing on improving speed. Speed is first punting. Na? Accuracy gone, presentation gone. Are you following, guys? Clear? Understanding? Okay. If you say cricket also, when somebody is learning cricket, first they will teach him how to hold the bat. Breathley will bowl for him. First they will learn how to hold the bat. Then they will teach him underarms lapota, how to hit in cover drive. Underarms lapota, how to, let's say, play in back foot. So he learns the skill, he learns how to present it well. Then only I will bowl fast for him. First ball, if I send one senior, put one bouncer, na gali, are you following, guys? That's how you learn anything. So all subjects, accuracy, presentation and speed. Sir, how do I improve this? Accuracy is concepts. Okay. Presentation speed, how do I improve that? Very simple. For accuracy only, just by doing questions, you will not get accuracy. Our presumption is you know the concepts. That's why for accuracy, for all of you, for free, I've given 3 videos of my class 12 hours concept, 40 hours concept, 80 hours detailed concept plus another 20 hours of new syllabus law. So this recorded class, why we are not doing this in the session? Most of you know the concepts. So for accuracy only, I have given you the proper detailed recorded 3 versions. Crash 12 hours, marathon 12 hours, crash 40 and 8 hours detailed concepts in detail is given to you. You can watch whichever you need. Plus for accuracy practicing only, now we are doing question answers. Correct? Next, this is available on the link guys, which is shared with you, or I will again reshare maybe in the chat in some time. If it's not there, I will again reshare in the chat. Then for presentation only, we are discussing questions. I am orally telling you how to present, and daily you have to do 2 activities. I will come to that. How to improve presentation, sir. The next 4 days, daily you write 1 question, which I am anyway checking over here. You are mailing to me. Online students are mailing to me. Those who mailed yesterday, we checked. Otherwise, I will check here for offline. Online can mail. I will do a separate session on that for discussing. Plus, sir, if I want to learn Hindi, eppadi kathuppa Hindi? I have to read Hindi first and then write Hindi, watch a lot of Hindi movies. See, how do I improve my English, sir? Hindi evidanga. I can improve my English only when I read a lot. Reading and talking in English only will help. Watch movies, 1. Movie only, so watching class. So 3 things. For improving any language, you have to watch, you have to read, you have to write. Only if you do all the 3, it will improve. Otherwise, how can I improve English? If I want to learn Hindi, first I should watch some Hindi movies. Then I should read in Hindi. Then I should write in Hindi. Ninga, how can you improve law language? First you watch classes. You watch guidance. Now you are seeing me. We are discussing questions. You are seeing all the answers. You are seeing how I should tell you. Adu mattum panna patadu. If I see somebody swim, I will have an idea. But now ulla ponu. So now you are in the stage where you are watching me. Where I am telling you what are all the common mistakes. Idella keywords. Next you have to read. Read what? I have given you 200 plus questions in PDF. All full syllabus 300 questions. You have to read these answers. Suma வீட்டுக்கு போயிட்டு இந்த ஆன்சரை paragraph படிக்கணும். Read. Keep reading. You will mark the keywords. Okay, personal skill is keyword in this question. Are you following? And then you should highlight all the legal representative. Highlight all the keywords while I am reading. Important words. அது மட்டும் பண்ணா போதுமா? You have to write. Write in exam, sir? No. Daily 5 questions. You'll no answer. In your house, daily you have to write 5 questions. Even from now, if you write daily 5 questions in law and 5 questions in accounts, any chapter, one chapter, 1 chapter from consignment, 5 questions, 1 from NPO, 1 from partnership, 1 from inventory, 1 from depreciation, and 1 from which chapter is difficult? Bill of exchange or company accounts. One question from each chapter if you solve daily. In the next, you still have how many days left for exam? 20 days irka? 25 days is left. 25 days into 10 questions, you would have solved 250 answers, accounts and law combined. So daily 5 questions in law, 1 in Contract Act, 1 in Partnership Act, 1 in LLP, 1 in Companies Act, 1 in Sale of Goods Act. Daily write 1. Daily 5 in accounts, each chapter 1. You have to spend the 2 hours in writing every day. What will happen? Before writing, you have to read. So read, you will see keywords, and when you write, you will know how much time it is taking. When you write only, you can measure the speed. Why I am asking you to write? To improve presentation and to measure speed. Daily eldunum guys. I have been teaching for 7 years in Chennai and other places. What I have noticed the most is results. Everybody knows the concepts. Those who got 25 also will know to give correct conclusion. It's about impressing that exam for those 3 hours examiner. அதுக்கு நீ practice பண்ணணும். For accuracy, this concepts. For presentation, daily one question in class. Classல one question. I can't ask you to write 5. So you read, watch, read and write, and you go home and you have to practice 10 questions daily. 5 in law, 5 in accounts. எழுதணும் guys. Not seeing. You have to write. And then towards the end, you have to take one mock test. That you're anyway taking a lot. Okay, that mock test is mandatory. That mock test will give you some more control. Are you getting it, guys? Okay. Fine. Let's come back here. Let's be a little fast now. I hope you guys got guidance online, understood. Okay.
Yes, sir.
Fine. I will give you those links. Just remind me if you don't have it, I will give it to you. Fine. Come back to question number 3. 20 questions. No stopping. We will go. Jooth entered into an agreement with Such to purchase Such's motor car for 5 lakhs. It's a contract. Okay, oral or written. Within a period of 3 months. Okay, 3 months I will purchase. A security amount of 20,000 was also paid by Jooth to Such. Advance, guys. When you go to buy a car, advance kudupingla. Like that, he paid advance of how much? 20,000. After completion of 3 months of entering into the agreement, Such tried to contact Jooth to purchase the car in terms of agreement. So 3 months kalsa I'm trying to purchase. Even after lapse of another 3 months, Jooth neither responded to Such nor his phone calls after lapse of another 6 months. So I gave advance to buy car. How much? 20,000. After 3 months I'm calling him, no response. Again I waited for another 3 months. 6 months அவன் ஃபோனும் எடுக்கல ரெஸ்பாண்டும் பண்ணல நான் அட்வான்ஸும் கொடுத்துருக்கேன். This leads to breach of contract. Promise made is to sell within 3 months. He has not delivered within 3 months. Jooth contacted Such and denied to purchase the motor car. Okay. He also demanded back the security amount of 20,000. Okay. From Such, referring to provisions of Indian contract, whether he is required to refund the security amount. Are you following the question, guys? அப்போனா இங்க question என்ன சொல்றேன்னா advance கொடுத்தவன். Who gave the advance here? Okay. J and S ன்னு வச்சுக்கலாம். J gave the advance of 20,000 to S, and then after for next 6 months, who was not contactable? J. Unable to contact J. Suddenly went into ghost mode. S is asking him, are you going to buy the car or not? No response. Now J is saying, காசு திருப்பி கொடு. Contract act la மறந்துருங்க guys. Common sense. Will he give the money back? No. If you go to buy a house or rent, you gave advance. You are not moving in. He will not give the full money back. Okay, common sense. So look at this. In terms of 65, where an agreement is discovered to be void or when a contract becomes void, first concept is what? Yeah, refund. Examine the validity of claim made by Jooth. If the motor car would have been destroyed within 3 months, then the agreement will become void as subject matter is destroyed. Okay, so 2 cases. First case, I am negligent. Second case, good is destroyed. So any person who has received any advantage under the contract has to compensate the other person. Referring to other provision, contract is not a void contract. Above is what? Valid contract. Because Jooth da respond பண்ணல. Therefore, Such is not responsible for Jooth's negligence. Therefore, such rescind contract can retain the security amount since it's not a benefit received under the contract. It is a security that purchaser would fulfill his contract. Second concept, in second situation, can you see second situation? In second situation, the contract becomes void due to destruction of the motor car. In that case, money has to be refunded. So 2 cases. First case, no refund. Second case, refund. Because first case is valid contract, it's a breach. Second case, void contract. Are you following, guys? Understood? Tanya, understanding? Okay. Next, question number 4. Mr. Murari owes payment of 3 bills to Giridhari as of 31st March. Good question. Came many times in past ICA sources. Exam la, they have asked only direct questions mostly in this. They are basically testing appropriation of payments. If you see appropriation of payments concept, we are splitting into 3. First case, who is specifying, guys? Debtor specifies. Second case, creditor adjust when debtor is silent. Last is both are silent. Sir, what is this, sir? Let's take the same values of question. Murari owes 3 bills to Giridhari as of 31st March. So who is the debtor here? Murari has to pay to. Okay. So Murari is the debtor. Giridhar is the creditor. அது எப்படி சார் எழுதுறீங்க? அது ரொம்ப ஈஸி. For Murari, who is Giridhar? Creditor. I have to pay Giridhar. For Giridhar, who is Murari? Debtor. உங்க ஆங்கிள் பார்க்காதீங்க. Who is the other person for me? For Murari, Giridhar is a creditor. ஏன்னா நான் பே பண்ணும். For Giridhar, Murari is a debtor because அவன் எனக்கு பே பண்ணும். ஓகே. இந்த லா என்ன சொல்லுது? ஃபர்ஸ்ட் இந்த டெட்டார் வந்து ஸ்பெசிஃபை பண்றான். இந்த லோனோட அட்ஜஸ்ட் பண்ணுங்கன்னா ஐ வில் அட்ஜஸ்ட் வித் தட் லோன். இஃப் டெட்டார் இஸ் நாட் ஸ்பெசிஃபைங் எனிதிங், creditor will, Giridhar itself will adjust by himself. If both are silent, then you will adjust which one? Time basis, which is nothing but first FIFO, first in first out. I will adjust on time basis. Earlier loan will be adjusted. Here we have an exception. Which one? In case of disputed loan, we should not adjust, and also in case of time barred debt. Okay. So look at this. 12,120 was due in May 2016. 5650 was due in August. 9680 was due in May. Murari made payment on 1st April after all the above loans as below, without any notice as to how to எப்படி அட்ஜஸ்ட் பண்ணணும் நம்ம எதுவுமே சொல்ல. First he made payment of how much? 9680. With what I will set off? First 12,120. No, I will set off with what? See guys, let me write all the values. What are the 3 loans? 12,120, 5650, 9680. 5650, then 96. These are the 3 loans. First loan, second loan, third loan. Now when it comes to payment, what is the first payment received? Of course you will be tempted to adjust with this, but I will not adjust with that, because even though instructions are not given, the 9680 is an implied instruction to set off with the same 9680. Are you following, guys? So first payment I will adjust with this 9680. Then he gave check of 15,000. Now I will adjust with what? The second 15,000. First I will adjust with 12,120. How much is left? 15,000 minus 12,120. How much is left? 2,770. This you will adjust balance with 5650. Now how much is left? 277. Correct guys, 2770. So now second loan la 5650 minus 2770, how much you are getting? Guys, I will again repeat, guys. Are you all understanding or not? First 9680 I will adjust with 9680. Next 15,000 I will adjust with 12,120. How much is extra? 2? யார் 2770 சொன்னது? Okay. Minus 12,120, you will get 2,880. This 2,880 I will adjust with 5,650 minus 2,880. How much is the loan left? 2,770 is the loan outstanding after all the payments. Are you following, guys? Understood? Okay. So this is the one. So what they are saying, since it is the exact amount, 9680 will be appropriated with 9680 even though it is paid late and it's later loan. Check of 15 can be appropriated against any lawful debt even though the same is time bar. That is exception. And instruction kudukalana, you can adjust even with time bar debt. Therefore you can adjust with 12,120 and balance against 5650. That's what we did. They have not done the computation and shown 2770. It's fine. எதோட adjust பண்ணனும்னு கேக்குறான். So he's saying adjust with 12,120 and balance with 5650. Are you guys following? Understood, guys? Okay. Yes. Okay. So time bar debt is allowed when the instruction is not given. Okay. Any doubts so far online?
Sir, can you hear me?
Yes, I can hear you, Srimani.
Sri Ramani, sir.
Oh yes, tell me.
Sir, actually it was a time bar.
Correct, it's a time bar debt. Yes.
First, why we could not take 12,000 for first?
Okay. So her doubt is, sir, for this 15,000, why can't we adjust with 12,120 first? Now, the concept here is, when 9680 is given without any instruction, it is an implied communication to set off with 9680 because both numbers are matching. Look at the wordings. It is deemed and understood. Look at this. One check was exactly the amount of the bill drawn. It would be understood that even though it is not specifically appropriated by Murari, even though he has not told, it will be against the bill of same exact amount. Hence, any check of 9680 will be appropriated against 9680, which was due in May 2019. Are you following, guys? Clear? Okay. Next. Question number 5. Anybody else? Any other doubts? Okay. Next. What will be the rights of promisor in the following cases? Rights of promisor in the following cases. Explain with reasons. Mr. X promised to bring, okay, in the promise the rights, contract valid, promise valid, not valid. Mr. X promised to bring Y back to life. It is void because it's impossible to perform. Impossibility of performance, supervening impossibility, void from starting itself. Sorry, it is not supervening impossibility, void ab initio. Supervening is subsequent. So bring to life again from the starting itself, void ab initio. Initial impossibility. Mr. A agreed to sell 50 kgs of apple to B. The loaded truck left for delivery on 15th March, but due to riots in between, it reached A on 19th March. Is it valid? Is it valid, guys? They have not given any other question details. Based on the question available here, I will say it's only. But depends on my assumption. Maybe some printing is missing over here. If the apples are destroyed, if apples are damaged, or if the party mentioned, I want delivery before some specific date, and then it is delayed, then the contract becomes void due to events not in our control. So look at the answer. Time is essence of this contract. As by the time apples reached B, they were already rotten. அப்போ question எங்கே கொடுத்திருப்போம். rotten is not given. It should be there, maybe some printing already rotten. The contract is discharged due to destruction of subject matter. Are you following, guys? That's why I gave assumption. Question la kudukla. If question is just this, it will be valid unless time is essence of contract, or we are assuming apples are rotten. Next, an artist promised to paint on the fixed day for a fixed amount of remuneration, but met with an accident and lost both his hands. What is this? Supervening impossibility. Initially, it was a valid contract, but subsequently, he can't perform. Therefore, it becomes impossibility to perform. Contract is of personal nature, cannot be performed due to occurrence of any event, resulting in impossibility in performance of contract. Are you all following, guys? Next, Abhishek entered into a contract of import of toys from China, but due to disturbance in the relationship between both countries, import from China was banned. Again, what concept? Supervening impossibility. Initially valid, sir. Now it is void because change of law. Such contract is discharged without any performance because subsequent illegality of the contract. Subsequently, it is illegal. Supervening impossibility. Are you guys following? Yes. Can somebody read question 6 for me online? Recording students, read by yourself.
Mr. Soma provided a loan of 80,000 to Mr. Tatman on 26 to 2019. The borrower, Mr. Tatumal, asked for a further loan of 1,50,000. Mr. Sonumal agreed, but provided the loan in parts at different rates. He provided 1 lakh on 28 to 2019 and the remaining 50,000 on 3/3/2019. On 13/3/2019, Mr. Ratumal, while paying off a part 75,000 to Mr. Sonumal, instead that the leader should adjust 50,000 towards the loan taken on 3/3/2019 and balance as against the loan on 26 to 2019. Mr. Sonumal objected to this agreement and asked the borrower to adjust in order to the order of date of borrowal of funds. Now you decide whether the contention of Mr. Dotumal correct or otherwise as far as the provision of Indian Contract Act 1872.
Go through the question, guys. Go through, try to answer. Again, appropriation of payments. So let's write down all the facts. Again, appropriation of payments, guys. There are totally 2 loans but 3 dates, correct? 2 loans but there are 3 dates. Let's write the date because here date is relevant. 26th Feb 2019, then 28th Feb 2019 and 10th March, correct? 28th Feb 19 and 10th March 19. First loan is 80,000. Next loan is 1,50,000. Other installment la kuduthirukkan 1,50,000. Then the remaining 50. 3rd March. Okay, not 10th. On 3rd March. Next 10th March, Tatumal paying of 75,000 he paid, and Sonumal insisted that the lender should adjust 50,000 towards the loan taken on 3rd March and balance against loan taken on 26th Jan. Okay. But Sonumal objected this arrangement and asked the borrower to adjust in the order of borrowed funds. So, on 10th March, So this is the guy who's the debtor and creditor here. Sonumal gave the loan, correct? Sonumal is creditor. Other person, what's his name? Datumal, who is the debtor. So Datumal took the loan from Sonumal, which is total of 2,30,000. I will again repeat, guys. For Datumal, other person's creditor. For Sonumal, Datumal is debtor. Okay, lender or borrower. So Sonumal is the lender, Datumal is the borrower. Now when Sonumal is when Datumal is repaying the money, who is repaying, guys? Datumal repaid how much? 75,000. அவன் என்ன சொல்றான் Datumal? He's saying adjust 50,000 in this, adjust 50,000 with 3rd March and balance you adjust with what, guys? Balance you adjust here. What is the balance? 25,000. So Datumal என்ன சொல்றான்? First நான் கொடுத்த 75,000ல லேட்டஸ்டா இருக்கிற லோனை க்ளோஸ் பண்ணிருங்கன்னு சொல்றான். So when he's paying, close the latest loan, and then he's saying அதுல இருக்கிற balance 25,000 adjust with the old loan, so it will become 55,000 outstanding, correct? But Sonumal என்ன சொல்றான்? the lender Sonu lender என்ன சொல்றான்? எதுக்கு இந்த மாதிரி காம்ப்ளிகேட் பண்ற லைஃப்? டோட்டலா நீ எவ்வளவு பே பண்ண? அத ஃபர்ஸ்ட்ல இருந்து தூக்குன்னு சொல்றான். In the order of time, look at him. Sonumal says, Sonumal objected this arrangement and asked the borrower to adjust in the date of borrowed funds. So அந்த lender சொல்றான், இந்த மாதிரி different adjust பண்ணி confuse பண்ணாத. Go adjust the first loan first. Who is correct here? Datumala, Sonumala? Who is correct, guys? Lender is correct, borrower is correct. What is the provision saying? We also saw above. If debtor or borrower specifies any way, then you adjust in that way. Who is the borrower here? So if Datumal is saying a specific manner, then we will do in that manner. Only when Datumal is silent, then you can adjust in the other way. So here is Datumal silent? No. அவன் clear-ஆ சொல்லியிருக்கான். First 50, then go for balance. Therefore, that's what we will do. Look at the analysis. We've given no. Datumal, while paying off 7,000 to Sonumal, insisted that the lender should adjust 50 towards the loan taken on 3rd March and balance against loan on 26th Feb. Look at the provision, guys. Where a debtor owing several distinct debts to one person makes a payment to him either in express intimation or under implying that the payment is to be applied to the discharge of some particular debt, then the payment, if accepted, must be applied accordingly. Therefore, the contention of Datumal is correct. Datumal is correct, and he can specify the manner in appropriating the payment. Only in second case, where the debtor has omitted to intimate and there are no circumstances indicating the debtor, then only creditor can apply at his discretion. Look at this here. Hence, in this case, Datumal fails to specify the manner. Second case, oh, they are giving answer in all cases. If Datumal fails to specify manner, then Sonumal can appropriate the payment in his own choice. He is correcting. Second case, enna solrana? If Datumal is silent, then only Sonumal can do in his choice. Third case, if both are silent, then you will see. Hence, in case if both are silent, then you can go in order of time. Are you following, guys? Clear? So how they have answered this? They have just given all three cases, but exam okay, they're asking contention of Datumal correct or otherwise as per the provisions of Indian Contract Act. So question is first asking is Datumal correct. I am also saying what? Yes, Datumal is correct. Later I am giving answer in other case also because they are asking otherwise as per provisions of Indian Contract Act. That too for how many marks? 6 mark question. So I am writing all the case. Sir, this same question is just for 3 marks. Don't write everything. Just write the first case alone. Are you following, guys? Clear? Or you understanding? Anybody has any doubts online?
Sir, I have a doubt regarding the previous question, sir.
Okay, yes, tell me.
Sir, for this everything is fine, but for the presentation alone, if it is of supervening impossibility, then we have to mention supervening impossibility and then we have to explain, isn't it? Or any other manner has been followed since it's a ABCD type question.
No, you can just mention the word supervening impossibility because of subsequent illegality. If you don't mention also, it's fine. They are looking for 1 mark question mainly for the words. It's void contract. You can give the point as supervening impossibility. Absolutely fine. Okay. Next, July 2021, past paper. X, Y, and Z jointly borrowed. The minute a concept is repeating again, I will be fast. Okay. They jointly borrowed 90k from L. Decide with reference to the provisions. Whether L can compel only Y to pay the entire loan, answer is. Whether L can compel only Y to pay the entire loan, yes. But later Y can recover from the other parties. Okay. Whether L can compel only the legal representative of Y to pay the loan of 90 if X, Y, and Z are dead. Yes. See, when it comes to L, for him, 3 people promised to pay him. Who are they? X, Y, Z. So if I am L, I gave loan to 3 of you together. வாங்கும்போது 3 பேர் வந்து வாங்குனீங்களா இல்ல ஒரு ஆள் வந்து வாங்கியிருப்பான் 3 பேருக்கு சேர்த்து. So for L, I took the loan from 3 people, X, Y, Z. So while repaying, I gave the loan. While getting it back also, I can ask Z, Y or X. Only between them, they will share it jointly. Whether Y and Z are released from their liability to L and X is released from his liability to Y and Z for contribution. If L releases X from his liability and sues Y and Z for payment, what is the question? அவன் என்ன சொல்றான்? Who are the 3 people? X, Y and Z who have to pay to? L is suing only Y and Z for payment. Just because L sued only Y and Z, the question is X released from payment, guys? He is released from the payment towards L, but he still has to pay Y and Z. Are you following, guys? Okay. One second, let me just. So first one answer is yes, L can compel Y to pay 90,000. In absence of agreement, promisee may compel one or more joint promisors. I think second answer we have a conflict. Let me finish third one. According to section 44, where 2 or more have made joint promise, a release of one such joint promisors by promisee does not discharge the other joint promisors. In case the release of X does not discharge Y and Z from their liability, Y and Z will remain liable to pay the entire balance to L. Although X is not liable to pay to L, he remains liable to pay to Y and Z. That's what we told. If X is released from L, X still has to pay Y and Z. So our discussion la first and third answer is correct. Only second I can see a conflicting answer. Let's read that. As per section 42, when 2 or more persons have made a joint promise, then unless a contrary intention appears by contract, all such persons during their joint lives and after the death of any of them, legal representative jointly with the survivor or survivors, and after the death of the last survivor, the representative of all jointly must fulfill the promise. In this case, if X, Y, and Z died, then the representatives of all X, Y, Z shall be liable to pay the loan jointly. Correct. L cannot compel only the representative of Y to pay the loan of 90. Okay, what they are trying to say here, they are trying to say if all the parties die, then the legal representatives should make the payment. Here L cannot compel only the legal representative of Y to pay. L should also ask legal representative of X, Y, and Z. But what if we do it like this? We have X, Y, and Z, and then we have legal representative of X, legal representative of Y, and legal representative of Z. Okay, LR, LR, and LR. Why can't L ask just this one fellow and this person can recover from others? No? Is that possible here is the question. Is that possible here? Why? So the concept of who took the loan, XYZ only took the loan from L and not the legal representative. So if you read the provision, it says all the persons during their joint lives and after death of any of them, his representatives jointly with survivors, and after death of the last survivor, the representatives of all jointly must fulfill the promise. So reading the act here, L cannot compel only one legal representative. L has to ask all legal representatives. Are you following, guys? So leave the point that we discussed earlier. So that is the correction over here, guys, in question 7. 1, 3 was correct. Second, we have to make that rectification. So quickly go through past exam question. Any doubts? Let me know here, online or here. Anyone, any doubts? Okay. Next, question 8. Look at this. How many times it came in the past, guys? Past paper, MTP, RTP, so many times. X, Y, and Z are partners in a firm. They jointly promise to pay 3 lakhs to D. So who are the three partners? Let's write it down. It will become easier. X, Y, and Z. They jointly promise to pay how much to D, guys? 3 lakhs. Y became insolvent and his private assets are sufficient to pay only 1/5 of his debt. X is compelled to pay the whole amount to D. Examine whether X can recover from Z. Simple. First, everyone should pay how much? 1 lakh. But who became insolvent? Y. His assets are available to pay only 20%, which is 1/5. So he can pay only 20,000. Therefore, how much Y cannot pay? Y is not able to pay 80,000. So what happened? This 80,000 will be shared by the other two in the ratio equally. 40,000, 40,000. Therefore, total amount payable by X will be to D 1 lakh 40,000. Z also will pay how much? 1 lakh 40, and Y is supposed to pay 20,000. So all put together he will collect how much? 3 lakhs. This is the amount that they are supposed to pay. But actually how much they paid? Look at the question. They are saying X is compelled to pay the whole amount to D. That means X paid how much? X paid the full 3 lakhs to D. That means how much he can recover from Z? 1 lakh 40 he can recover. Are you following, guys? So what they were supposed to pay is 1 lakh, 1 lakh, 1 lakh. But because Y is paying only 20,000, remaining 80 is shared between the other two. So it becomes 1 lakh 40, 20 and 1 lakh 40. Are you getting it, guys? But since he paid 3 lakhs, he will recover 1 lakh 40 from the other person. Look at this. He will recover 1,40,000 from Z. Sorry? Correct. So how D will recover? D will get 20 from Y and 1,40,000 from X and Z. That will be the actual share. Okay. So X will recover 1,40,000 from Z and 20 from Y. Okay. Next. Yeah, no problem. Next. We'll come from reverse now, just for change of type of questions. We have totally 21 questions. Yeah. Just coming in reverse, just for some change, that's it. S promises M to paint a family picture of 20,000 and assures to complete assignment by 15th March. Unfortunately, S died in a road accident on 1st March and his assignment remains undone. Can M, the legal representative of S for the promise made by S, can he do the painting, guys? No, because it is personal skill. We just now saw that. Next, suppose S had promised to deliver some photographs to M on 15th March against the payment of 10,000, but he dies before that day. Will the representative be bound to deliver the photographs in the situation? Yes, delivering photographs. அங்க போய் photo எடுக்கிறதுக்கு என்ன personal skill? Unless there is some reputation. So here, in first case, since death, there is use of what skill? Personal skill. Second, promise deliver photographs, he will be bound to deliver because there is no personal skill. Understood question 21? No? Easy, guys. Question 20. Can I have someone online read question 20 for me quickly?
In the light of provisions of the Indian Contract Act 1872, answer the following. Mr. S and Mr. R made contracts wherein Mr. S agreed to deliver paper cup manufacture machine to Mr. R and to receive payment on delivery. On the delivery date, Mr. R did not pay the agreed price. Decide whether Mr. S is bound to fulfill his promise at the time of delivery.
Simple. Forget this question. You ordered food on Zomato. Now the Zomato, Swiggy and Zepto are fighting. That you should take as advantage. What, sir, they are fighting? You have Zomato. You have, I'll explain the question also, guys. Don't worry. Middle, some small distraction to get some general knowledge also. Now Zomato recently launched, and we have this Zepto, one new fellow. Okay. Because Zepto came saying I will deliver in 10 minutes, which they are actually doing. If you order, it comes to your house in 10 minutes. You all know Zomato launched what? Blinkit. Swiggy has Instamart. Then what happened? Zepto now launched a new thing called Zepto Cafe. What is Zepto Cafe? Within the app they are launching. They will deliver food in 10 minutes. Not all the food, not biryani, samosa, tea, snacks, cake, puff, sandwich. Adala ready irukuma. They will deliver in 10 minutes. So Zomato also said we will launch in 10 minutes. Swiggy also said we will give food in 10 minutes. They launched something called Bolt, and Zomato launched something for Zomato Cafe and something they called it. I forgot the name of that. What is that Zomato? It's something is there, guys. Fine. Okay. They will deliver in 10 minutes. Then Swiggy, Zomato launched just 1 month back an app called District to book your movie tickets, etc. events. District. Swiggy just 2-3 days back, they also wanted to compete. They launched Scenes for booking movie tickets. So all of them are competing. Now Zomato is different. Na? Zomato tani app, District is separate app. Swiggy, everything is there in the same one app. Okay, now let them fight. Swiggy just now raised 18,000 crores. Zepto has some 25,000 crores. Zomato also has some similar money. Let them fight. நம்ம என்ன பண்ணோம், நிறைய டிஸ்கவுண்ட் கொடுப்போம். Use the discount and order it. Okay, that's it. If you want to use it, you can use, otherwise leave it guys, let them fight, you will use it. If at all you're ordering lunch, no, Zomato is giving some flash sale 50% off on solitana. So if you want, you can use the discount. Otherwise, if you have the energy, if you don't want to get lazy, go to nearby shop, buy and come. Of course, the price that these people give is going to be cheaper. They're giving in discount just to make you lazy. But the best thing what you can do is, in my house they don't allow me to order these. Not for groceries, we can't order, my wife won't allow. Food okay, no other option. Zomato only I have to order the food. Adukadha. But groceries, buying eggs, or let's say buying vegetables, that we, even though it is what to say cheaper, in my house we will not buy here. We will go to the nearby shop and buy, or the nearby shop itself now has delivery. Okay, nearby that small kirana shops, they have delivery. So we will call them and tell, they will come and deliver. Of course the price is going to be little higher, but that's okay, because these fellows will not give discount forever. They will give only 1 2 years. But as long as they're fighting, just be aware of what is happening in the market guys. Just some general knowledge. Now why I discuss this, let's say in Zepto you ordered some products for 500 rupees. Okay, they will come and deliver in 10 minutes. They came to your house to deliver, you didn't give the cash, will you give the goods? COD, you are not giving cash, will you give? No. Reciprocal promise means both the parties should be ready to perform the promise. That's what they are saying here. Is S bound to fulfill the promise at time of delivery? No, because he has to receive the payment. If R is not paying, then only one party is ready to pay. Both the parties are not ready to perform. Only one is ready, then contract will not. So S is not bound to deliver since R was not making the payment at the time of delivery of goods. In a concept of reciprocal promise, na term is fancy. Reciprocal promise, na both the parties should be ready to perform the contract. Sir, I called one plumber to my house, or let's say I called electrician to my house. Why sir? Fan is not working. What he should do? Get up, move the bed, stand on the bed with some stool and repair the fan. I am sleeping, நான் தூங்குறேன். How எப்படி ரிப்பேர் பண்ணுவோம்? I am saying I can't get up. How he will repair? He can't. I am not ready. Plumber came home to fix the tap. Someone is taking bath. How can I repair? Not possible. Both the parties should be ready, willing and cooperate with each other to perform the contract. Okay. Or even if you paid for Swiggy, you paid the money, nobody is there in the house, then what you will do? How will you deliver? Can't deliver. Are you following guys? Okay. Once what I used to do long back, not now, or 7 8 years back, okay, now you can't do it guys. That's why I'm telling. With one of my friend, I fought with him. Okay, சரி அவன் எப்படி பழி வாங்குறது ஏதாவது பண்ணணும்னு சொல்லி I went to the Swiggy app. I ordered 10 burgers. Bill was 4,500 rupees something. Okay, then I put COD to his house. அவன் வீட்டுக்கு COD போட்டேன். Those days COD there was no limit. Initial days when Swiggy was launched, now everything is UPI. Now Swiggy Zomato has a limit, COD 500 or 1000 rupees. Beyond that you can't do. But initial days la apdi illa. So night around 1:30 am I placed the order and slept off. COD to his house. Then I don't know what happened. Next day then he also said he won't pay. Then that food and all got not right guys. But initial years, I think 2014 or something, when they initially launched, just for time pass we used to do that. Okay, we'll come back to question 19. Yes, somebody read that next. Question 19 online, whoever reads first. Okay, continue Hasana. Yes, next I'll pick offline. Yes, அங்க படிச்சா இங்க கேக்கும், அதனால. Yes, go ahead Hasana.
Nitish Gupta is constructing his house. For this purpose, he entered into a contract with Messrs. Baba Brick House to supply of 10,000 bricks on 12th August 23. Messrs. Baba Brick House has two lorries of 5,000 brick capacity. On 12th August 23, one of the lorries was not in working condition, so Messrs. Baba Brick House supplied only 5,000 bricks and promised Nitish Gupta to supply rest 5,000 bricks on the next day. Nitish Gupta wants to cancel the contract as Messrs. Baba Brick House did not supply the bricks as per the contract. Messrs. Baba Brick House gave the plea to no fault has been made from his part. Hence, contract should not be cancelled. In this situation, whether Nitish Gupta can avoid the contract under Indian Contract Act 1872.
Go through the question, guys. Answer, guys. Can he cancel the contract? Can he cancel? Can Nitish Gupta, who's Nitish? Whether Nitish Gupta can avoid the contract is the question. Can he avoid? Simple. You go to theater and you wanted 3 popcorns. Okay. In interval, that person told he will come and give to your seat. நீங்க போய் உட்காருங்க sir. Okay. வரவே இல்லை. Then after 20 minutes he came and gave 1 popcorn and told, after the movie I will give the balance. Will you accept? Why I want 3 popcorn? நாங்க 10 பேர் இருக்கோம், we can share. 1 popcorn nobody can eat properly. So here it is very clear that Nitish Gupta, for constructing his house, he entered into contract to supply 10,000 bricks on 12th August. Here Baba Brick supplied only 5,000 bricks as of 12th August and balance he did not supply. Don't come to practical side of it. Look at the law. The law here says what? Part performance is not equal to full performance. Part performance is not equal to full performance. Sir, practically Nitish Gupta will adjust. இன்னைக்கு 5,000 bricks, next week 5,000 bricks. Practically யார் சார் அப்படி இருப்பாங்க? I am going as per law. As per law, look at this. Hence the part performance of Baba Brick cannot be taken as a valid performance. Other party also should accept. Like let's say you ordered in Swiggy 2 pizzas Domino's and let's say 1 cake. They gave only 1 pizza. Will you accept, guys? He will come and give the other one after 2 hours. சொல்றான், ஒத்துப்பீங்களா நீங்க? No. So part performance is not full performance. Next. Question 18. Yes, we will have someone from Google Meet to read. Yes, Kirtika, can you read it?
Yes, sir. Mr. Ayush, the employer induced his employee, Mr. Bobby, to sell his 1-room flat to him at less than the market value to secure promotion. Mr. Bobby sold the flat to Mr. Ayush. Later on, Mr. Bobby changed his mind and decided to sue Mr. Ayush, examining the validity of the contract as per the provisions of Indian Contract Act. Mr. Suraj promises Mr. Manoj to paint a family picture for 20,000 and assures to complete his assignment by 15th March 2023. Unfortunately, Mr. Suraj died in a road accident on 1st March 2023 and his assignment remains undone. Can Mr. Manoj bind the legal representative of Mr. Suraj for the promise made by Mr. Suraj? Suppose Mr. Suraj had promised to deliver some photographs to Mr. Manoj on 15th March 2023 against a payment of 10,000, but he decides before that day will his representative be bound to deliver the photographs in this situation?
First question from previous chapter it is, Ayush induce the employer. What concept is this? Undue influence. Can he sue? Can Bobby change his mind and sue? Yes. Agreed party. Second, Suraj promises Manoj to paint a family picture for 20K and assures to complete by 15th March. Died in road accident. Therefore, can his legal representative do it? No. Same question. Legal representative cannot do the painting. He promised to deliver some photographs. Can he do that, guys? Yes. Basically, two questions we are repeating again. Okay. Next. Question number 17. This loan also is very similar to previous question. Sir, why are questions repeating? I am not removing duplicate questions. All the past exam questions which came, I am adding. Okay. It's good if it repeats. That means you know this concept they have tested multiple times in a different form. Okay. This question also we saw. Sohan, a wealthy man, provided loan of 80K to Mukesh. நம்ம சோஹன் முகேஷா பார்க்கல, நம்ம என்ன பார்த்தோம்? யார் அந்த ஆள்? சோனுமால் தத்துமால் ஞாபகம் இருக்கா? அந்த தத்து சோனு, தட் ஒன். ஓகே, அதே கொஸ்டின் தான். 75,000, சேம் திங். Are you following, guys? We will go to the previous one. Next, this also is same one, guys. Question number 16. It's just a different attempt and amount is changing. But this one let's discuss, because last time when we did this, some of you had challenged. Harish owes 3 bills as of 31st March. 12,120, 5650 and 9680. I think same question. Yeah. 9680 you will adjust with 9680. 15,000 first to 12,120, then balance 5,650. Are you following, guys? Maybe I will just remove this because it's actually the same question. Okay. Next. மறுபடியும் அதே question. Past exam paper. Promises to paint a family picture. அதே தான். Then supply photographs. Family picture can he paint, guys? Assignment. No. Photographs he can deliver. Okay. Question 14. This is different. Yes, somebody else read question 14, guys, fast. Online we will have a yes, Hasana, can you read question 14 for us quickly?
Mr. Shingania entered into a contract with Mr. Sonu to sing in his hotel for 6 weeks on every Saturday and Sunday. Mr. Singania promised to pay 20,000 for every performance. Mr. Sonu performed for 2 weeks, but on the 3rd week his health condition was very bad, so he did not come to sing. Mr. Singania terminated the contract, state in light of the provisions of Indian Contract Act 1872. Can Mr. Singania terminate the contract with Mr. Sonu? What would be your answer in case Mr. Sonu turns up in the 4th week and Mr. Singania allows him to perform without saying anything? What would be your answer in case Mr. Sonu sends Mr. Mika on his place in 3rd week and Mr. Singania allows him to perform without saying anything?
So Singania entered into a contract with Sonu to sing for 6 weeks on every Saturday and Sunday. Singania promised to pay 20,000 for every performance. Sonu performed for 2 weeks. That means she has to get how much? 40,000. But on the 3rd week, his health condition was very bad, so he did not come to sing. Mr. Singania terminated the contract, state in light of the provisions of Indian Contract Act the following. Can Singania terminate the contract with Sonu? Yes, வேலைக்கு வரலனா terminate பண்ணுவேன். What would be your answer if Sonu turns up in the 4th week and Singania allows him to sing without saying anything? Then contract will continue. That means there is a breach. You had the choice to rescind the contract, but you allowed the performance. What would be your answer if Sonu sends Mika in his place in 3rd week and Singania allows him to perform without saying anything? Yes, then also contract will continue. Let's look at the answer. As per section 40, if it appears the nature of the case, intention of the parties, any contract that promisor contained, it should be performed by the promisor himself. Then promisee must, then only I should perform. Where a promisee accepts performance from a 3rd person, he cannot afterwards enforce it. That means if you accept somebody else to perform, later you can't tell why you did not perform. First case, Sonu could not perform. He can repudiate. Yes, he can rescind the contract. Second situation, Singhania allowed Sonu to perform in the 4th week without saying anything. Singhania had given his assent to continue. Singhania cannot terminate. Maybe he can claim damages for that 1 week of not coming. In case Singhania allows Mika to perform the 3rd week without saying anything, by conduct, it's an implied acceptance. Mr. Singhania had given his assent for performance by third party. Singhania cannot terminate nor he can claim damages because you allowed third party to perform. This is question number 14. Question 13. Past exam paper plus RTP. In light of provisions, S&M are contract delivered paper cup. Oh, same paper cup. Fine, that same paper cup point, but part performance is not equal to full. Art didn't pay the agreed price. Oh, reciprocal promise. If one party is not performing, then the contract can be cancelled. Okay. Next. Question 12. J contracts to take in cargo for K at a foreign port. J's government afterward declares war against the country. Therefore, contract could not be performed. What is it? Subsequent or supervening impossibility. We finished all these, huh? No, okay. Next, just 3 more questions to go. 12 is over. 11. A, B, C, D are 4 partners in a firm. They jointly promised to pay 6 lakhs to F. B and C have become insolvent. B was unable to pay any amount and C could pay only 50,000. A is compelled to pay the whole amount to F. How much can A recover from D? Can you try it out, guys? Try it out. I have done a similar sum. Those who are watching online here also, instead of looking at my face, try to solve this sum, guys. Don't look at the answer. Just try to solve. Exactly find out the final answer what they're asking. What is the final answer they're asking? Final answer is how much can he recover from the other person. Okay. I'm getting the answers. Let me write the answers. One answer I'm getting is 2,75,000 is one answer. More answers, guys. Anybody else? More answers? Some other answer. Somebody told 2 lakhs. Online here.
Sir,
Yes.
actually, this one is not a partnership now because partners must be in a business form, but it want to pay a liability now.
No. They are clearly saying it's a partners in a firm. So we are not going to counter that part. Okay. So what is happening here, guys? A, B, C and D jointly should pay how much? 6 lakh, correct? That means what was the original share? They have to pay equally. What is 6 lakhs by 4? 1 lakh? 1 lakh? So each of them are actually supposed to pay
1 lakh 50,000.
50. But who's not able to pay anything? B is paying 0, C is paying. Correct? Correct. So what is the total loss? Total losses. This guy should pay 1,50,000. This guy should pay 1,50,000 plus 1. So the total will become 2,50,000. This 1,50,000 and this 1,00,000 should be payable. This 2,50,000 I will split between the others first. Okay. So how much is that? 1,25,000 each. So plus 1,25,000 plus 1,25,000. So based on computation, how much is A supposed to pay now? 2,75,000. B is 0 because it's insolvent. C anyway paid 50,000. D is supposed to pay again 2,75,000. I will check if I add everything. Am I getting 6 lakhs? Yes, if I add everything, I am getting how much, guys? 6 lakhs comfortable over. Okay. But actually, who paid the full amount? A. A paid full. 6 lakhs was paid. How much A will recover from C? 50. How much he will recover from D? 2,75,000. So from C I will recover 50. From D I will recover 2,75,000. அவங்க கேட்கறது how much you can recover from D? The answer will be 2,75,000 plus 50. Totally he can recover from C and D 3,25,000. That only we also discussed. 50 plus 2,75,000 is how much, guys? 3,25,000. Are you all able to follow, guys? Understanding? Last row. Following. Next question 10. X received certain goods from Y and promised to pay 60,000. Later on, X expressed his inability to make the payment. Z, who is known to X, pays how much? 40,000 on behalf of Y. See, you have to pay 60. You are not able to pay. Your friend paid me how much? 40. I took it. Now later, X was not aware of this payment. Now Y is intending to sue X for full 60. Can he do that? No, he can sue only for 20,000. So what is this? Performance by third party. We have X, Y and Z. First, who has to pay to whom? So X has to pay to Y 60, guys. He was not able to pay. Therefore, how much Z paid to Y? 40,000. But Z pay பண்ணது X is not aware. Y taking advantage of this. Y paid to X how much? He sued him for 60. Can he sue for 60? No. He has to set off with the 60 and 40. He can sue only for 20. What concept is this? Performance by third party. Okay. Fine. Last question. Question 9. Yes. Quickly go through, guys. Somebody will read this. Yes, we will have online who is yet to read it. Padma Shri. No response. Okay, Padma Shri, yes. Yeah. Can you read the question 9?
Mr. Excel Silverman entered into a contract on 1st August 2018 by which Mr. X had to supply 50 tons of sugar to Mr. Y at a certain price strictly within a period of 10 days of contract. Mr. Y also paid an amount of 50,000 towards advance as per the terms of above contract. The mode of transportation available between way only. Safety it came on 2nd August 2018 and the only road connecting the places was damaged and could not be repaired within 15 days. Mr. X offered to supply sugar on 20th August 2018, for which Mr. Y did not agree. On 1st September 2018, Mr. X claimed compensation of 10,000 rupees for refusing to accept the supply of sugar, which was not within the purview of contract. On the other hand, Mr. Y claimed for refund of 50,000, which he had paid as advance in terms of the contract. Only the above situation in terms of the provisions of the Indian Contract Act 1872 and decide White's contention.
Yeah, enough. No, enough. We'll finish this question, then go to the last one because question 8 is done. Last one, this chapter will get over. Go through first paragraph, give me the answer, guys. Simple. You know the concept. Basically, what is happening? X is delivering to Y 50 tons of sugar, for which Y paid how much? 50,000 as. But unfortunately, X could not deliver, not because of X fault, but there was a severe flood. So he could not deliver on the time of 2nd August. And then later he delivered only on, he was able to deliver only on 20th August, which came almost 18 days late, for which Y did not accept delivery because there is a delay. Now contract is not performed because of impossibility, supervening impossibility because of some other event not in my control. So if a contract becomes void, what is the consequence? You have to reimburse the money, the reimbursed amount back. Therefore, this 50,000 has to be reimbursed. Now, X enna kekran, you give me damage of 10,000 because you are refusing to accept delivery. Can he ask damage of 10,000? No, because contract is void. Are you following, guys? Okay. So the concept here will be supervening impossibility. Contract becomes void. Put the parties in a position as if the contract was never entered. So the money has to be refunded. You can't claim for 10,000 for non-accepting delivery because he has the right to not accept delivery because there is delay. Both the parties are not to be blamed. Last question. Gaurav and Vikas entered into a contract on 1st July. Same question, no? Yeah, same question. Some roadways, severe flood, just different numbers. That's it. Came so many times in past exam and MTPs. Okay. X. X claimed answer கேக்குறீங்களா? X claimed compensation, Vikas refusing to accept. No, he can't claim. ஆமா இங்க வேல்யூ அதானே. ஹீஸ் கிளைமிங் எக்ஸ் கிளைம்டு 10,000 கேட்டிருக்கான், எனக்கு வேணும்னு கேட்டிருக்கான். கிளைம்டு காம்பன்சேஷன், எனக்கு காம்பன்சேஷன் வேணும்னு கேட்குறான். ஓகே, ஸோ ஆன்சர் இஸ் டு பே பேக் 50,000 for the advance. You cannot claim any advantage. You cannot claim the compensation. Are you following, guys? Okay. With this, we are done with unit 4. We just have unit 5. Okay. Sir, like this only questions will come in exam? No. I will give some time later towards end of the batch something called, did I tell about this in yesterday's class? So expected questions is basically what came in the past plus new questions that can come in the future. What has come in the past now is only what we are discussing. These are about 7 to 8 concepts. New untested concepts also are there. For example, in unit 4, performance of contract, discharge of a contract, questions are not yet tested. So there are still many untested concepts. So the expected question list, what I will do, past tested I will add a few points which are important, plus untested areas எது test பண்றதுக்கு worth இருக்குன்னு சொல்லி those things also we will add, and then the new list will be ready. That I will give at the end of the batch. Okay, fine. Now we will go for a short break. What's the time now? 12:15. We will resume at 12:30 p.m. and take the next chapter then. Okay. Same link, nothing to change. Settle down, guys. Settle down, all of you. Yeah. Online, am I audible to you guys? Ready to start?
Yes, sir.
Google Meet, am I audible for you? Yes. Okay. Okay. Let's start off, guys. Okay. In this session, what we are going to do, we are going to discuss past exam questions from breach of contract and remedies from the last 6 years. Okay. Now, breach of contract and remedies, let me give you a chapter overview. The chapter is very simple. It talks only about two things. What is breach? What is remedy? That's it. Breach now promised for something that never took place. So here they are saying they are classifying this breach itself into two types. One is actual breach, another one is anticipatory breach. Sir, what is actual breach? What is anticipatory breach? Now, actual breaches, let's say, okay, let me give an example. You booked cab on Ola, or let's say you booked cab on Uber, cab or auto or Rapidola, you booked a bike. Okay, it's saying estimated time of arrival 7 minutes. Rapido varum irukku. Okay, now you are waiting in the location. 7 minutes is same 7 minutes for 10 minutes. நானும் வெயிட் பண்ணுறேன். Then suddenly that 7 minutes has become 11 minutes. போகிறோம். You can see in the map he's going somewhere else. Will you still keep waiting there? என்ன பண்ணுவீங்க? You will cancel. Now, that means this is an anticipatory breach. Anticipatory breach na, even before the actual performance is due, he was supposed to come within. That means there is still 7 minutes for him to come, but before this time is over, it increased to 11 minutes. That means you know he is going in the opposite direction. So if there is going to be an anticipatory breach, if there is going to be anticipatory breach, you can do one thing, like how you said, you will cancel. That means you will rescind the contract, or some people will wait. Okay, maybe எனக்கு அர்ஜென்ட் இல்லை, ஐ எம் டாக்கிங் டு சம்படி, எங்கேயோ போய் சுற்றிட்டு வரான் போல, I will wait. You will wait. You will basically anticipate and wait till the performance is due. So if there is going to be an anticipatory breach, I am guessing there is going to be breach. You can do two things. What are the two things you can do? One is you can cancel or rescind the contract. Second, you can wait till the actual due date. Can you give me some other examples for anticipatory breach? Let's say in urban company, you can book a service like carpenter, or let's say plumber or electrician. Let's say you needed some work, so you booked an electrician for your house. Message came saying he will come at 2 p.m. His number also came. Number came at 11 a.m. From 11 a.m. I have been calling him at least 20 times. He never picked the call. Now I have a doubt. 1:30 க்கும் கால் பண்ணேன். 1:30 p.m. க்கும் I called to check if he is coming. Electrician. Phone எடுக்கல. Now this could be an anticipatory breach. What you can do, you can go to the app and cancel the contract because he is not responding, or wait பண்ணுவேன். I will wait till 2 p.m. Maybe he will come. Maybe he has different number. Maybe வந்துருவான் போல. Okay. So anticipatory breach is basically you are anticipating before the due date, and action can be cancel or wait. What is actual breach? Actual breach na at the time when the performance is due. At the time when the performance is due, at the actual time when the performance is due, at that time you are not performing. Are you following, guys? At the actual time when the performance is due, you are not performing. Can you give me an example of this? Movie is supposed to start at 7 p.m. Movie show is cancelled. After you went to theater and sat down, 7:30 p.m. they are saying projector is not working. What you can do? You can cancel the contract, of course cancel, and also claim damages. In both you can claim damage. So actual breach na at the time when performance is due, you have cancelled. So now you have learned to an extent what is breach of contract. So we are clear with the breach of contract. Next we have to go for remedies. Sir, what are the remedies? There are multiple remedies available, not one, not two. நிறைய remedy இருக்கு. Depends what remedy you want to take. Let's take an example. You booked Rapido. அவன் வரணும் வரல. He has not come. You have cancelled the booking. He also cancelled or you cancelled booking. The case போடுவீங்களா? What you will do? Just cancel. Are you going to fight with that person who cancelled or did not come for Rapido or Uber? No. If you want, again I'm repeating, if you want, when you booked Ola, after accepting if they are not coming, you can file a case. Neither lose up. Go to court, file a case. Okay, you won the case. Ola cab was supposed to come, he didn't come, you won the case. What you will get? Compensation. 100 ரூபா. Okay, because my auto charge was 100 rupees, he didn't come, he will give you 100 rupees. That means you have the right to go claim damages, but will you do it? No. So depend upon the type of breach, you can go for remedy. So remedies for breach of contract, one type of remedy is called rescission of. Can you see rescission of contract? That means you will cancel the contract. Can you tell me cases where you will just cancel and leave it? Ola Auto, Uber, Rapido, then Zomato, COD you put. Once I put COD, I went to India versus England test match which happened in Chepak. Okay. It's whole day. Test match na morning 9:30, 10 till 5 p.m. I should be there. So lunch சாப்பிடணுமா? ஸ்டேடியம்ல ஜென்ரலா ஃபுட் கவுண்டர்ல crowded இருக்கும். Okay, depends. IPL will not be that crowded because they will come to the place where you are sitting and give the food, and IPL will have lot of stalls. Like IPL பாத்தீங்கன்னா, when I went for IPL matches, there will be many stalls. Every 100 meters one full stall will be there, plus they will bring food to your seat. நீ எந்திரிச்சு போக வேணாம், because IPL match 2 hours, 2-3 hours. அந்த நீ போயிட்டு வரதுக்குள்ள 10 over காலி ஆயிடும். So they will bring popcorn, burger to your seat, so it's easy. But test match is not like that. They will not bring anything. You should only go and buy, and the number of counters for test match is limited. So that day that it was heavily crowded for lunch, we were 3 of us, and the queue lo poi varthukula I didn't have energy, so I ordered on Swiggy. He can't come inside the stadium, but he can come near stadium gate. Stadium gate கிட்ட வரலாம். What mistake I did? I went to stadium. That day in food counter, Domino's was there. That's why heavy crowd was there for Domino's. Sari, who will wait in the queue? I will order in Swiggy in Suli. I ordered in Swiggy. He never came for 4 hours. It said order is on the way, order is on the way. Suli 4 hours are there. That means that day Domino's was not able to deliver the order because of heavy demand around the stadium. That branch was full. So what I will do? Will I file a suit against them and go to court? என்ன பண்ணுவேன்? Rescission, cancel the contract, claim my refund if anything is there. But if I want, okay, are you following this? Let's say next example, understanding when you should claim what. Next, let's say, okay, in Tamil movies big budget movie வரலையா, or big budget movie வருது, hit ஆக மாட்டேங்குது. Telugu Pushpa, Bahubali, Kannada KGF, Kerala you have Manjumal Boys, all are getting big hit. நம்ம ஊரில் படமே வரலையே. So let's say fine, they have decided to shoot one next big movie. Let's say Rajamouli is saying I will take one Tamil movie. Let's say hero is STR. Okay, 75% shooting is done. Climax alone pending for shooting, that is balance 25%. Now STR is saying I will not come, cancel. STR immediately went for some other movie. Let's say Maniratnam is shooting a movie. STR, instead of coming for this movie, he started going for the second movie. Now if I am Rajamouli, will I cancel this contract? Cancel பண்ண எனக்கு தான் loss, because you have acted for 75% time. நீ தான் பா climax நடக்கணும். Nobody else can come and do the shoot. So this time I will not go for rescission of contract. Okay, I mainly want what? I will not go for suit upon quantum merit also. எனக்கு என்ன வேணும், நீ வந்து first you finish the acting. I will go for suit for specific performance. I will sue him asking him to come and act and finish the movie. If he is not coming, what he is doing? He is acting in some other movie. I will go for suit for injunction. In suit for injunction, it is nothing but a stay order asking him not to act in the other movie, asking him not to act in the other movie until this movie is completed. Are you following, guys? So suit for specific performance is taken when you want that person to perform. Suit for injunction is taken when? Injunction when you don't want some, let's say my house is there, my land is there, agriculture land is there. Some corporate company came to my agriculture land and they started building factory. எனக்கு கேன்சலேஷன்லாம் வேணாம், ஃபர்ஸ்ட் நீ நிறுத்து வேலையை. That is my house, my land. So suit for injunction will be taken when you want someone to stop doing what they are doing. Because of that, I have a loss. So what are the remedies that available, guys? Rescission na cancellation. Suit for specific performance na asking him to perform that. Suit for injunction is what? Stay order, stopping him from doing. Suit upon quantum merit, you guys know. What is quantum merit? If somebody performs part performance, get payment for that part. Are you getting it, guys? Classic example for part performance. You got into cab. You are going from your house to friend's house, which is 15 kilometers away. After going 8 kilometers, the cab broke down, puncture. Can he go? No. What you should do? Get down, take some other vehicle and go. Initial plan was 15 kilometers, 300 rupees. Half the distance he went, should you pay? Yes. What? No. He took you for 8 kilometers. He at least, instead of paying 300, he will ask, at least pay me 100 rupees. Correct? On road, I don't have an option. I'm leaving you in the middle of the road. But at least pay me 100. Suit upon quantum merit will come when part work is done. At least pay for that part. Next is suit for damages. What is suit for damages? Let's say Diwali is coming, or let's say New Year is coming. Okay. For New Year, you went to sweet shop. It's going to come in 2 weeks from now. So you went to sweet shop, you wanted to buy sweets. You ordered 100 kg of Kaju Katli at rupees 500 rupees per kg. Total is 50,000. You paid advance of 10,000 in the sweet shop. Let's say Shri Mithai. You wanted Kaju Katli from Shri Mithai. So you went and paid how much, guys? 50,000. 50,000 is the amount you're supposed to pay. You paid 10,000 advance. Then you went on 31st December morning to collect this 100 kgs. So you can distribute to your friends and family on 31st and 1st. Then he's saying, "Ayo, sorry sir, unga order marandten. If you want som papadi is there, you will take or laddu is there, will you take? எனக்கு என்ன வேணும்? Kaju Katli, that's why I came to your shop. If I want laddu, வேற எங்கேயாவது போயிருப்பேன்." He's saying, "Sorry, now I can't make Kaju Katli. I'm accepting the mistake. What to do?" What you will do? Sorry, I want Kaju Katli somehow. So Srimitai forgot your order. So you will go to some other competitor who can deliver. You went to Sri Krishna Sweets and told him, sir, somehow I need Kaju Katli. நாளைக்கு எல்லாருக்கும் கொடுக்கணும் எனக்கு. I already told people I will come and give sweets. Sri Krishna Sweets is saying, okay, 100 kgs நான் உனக்கு பண்ணி தரேன். எனக்கு ஒரு 6 hours டைம் கொடு. 31st மார்னிங் வந்தியா, ஈவினிங் வா, நான் உனக்கு பண்ணி தரேன். 100 kgs, how much he will charge per kg? Same 500? No. Last minute order, demand is there. He will charge 800 per kg. I will pay because எனக்கு வேணும் இந்த sweet. So I am paying how much? 80,000. Now because Sri Mitai did not give me the goods on time, I had to purchase from somebody else by paying how much extra? By paying 30,000 extra. I had to pay how much extra, guys? 30,000 extra was payable by me. This 30,000 only I will claim as damages. Damages na எனக்கு compensation வேணும்பா. That is what damage? Ordinary damage. What damage, guys? Ordinary damage. Okay, what is the loss? Here 30,000 is my ordinary damage. Then what is special damage? Let's take the same example. Okay, same example. And my plan was to buy these sweets, and I have a contract to deliver these sweets to government New Year function. Okay, government is conducting a New Year function on 1st Jan 2025 with the Chief Minister plus all the ministers. For that I am doing catering. For that I am purchasing Kaju Katlis for how much? 50,000. And this Kaju Katli I am going to convert to Kaju Katli ice cream. New flavor in the New Year function. So I signed a deal. In the government function ko enakku sambandham illa. I am just a catering. That too I am catering only ice cream. So from 100 kgs of Kaju Katli, my plan was to make 200 kgs of ice cream. Ice cream, it won't be only Kaju Katli, I will add other items also. Correct? And government sanctioned a deal with me, 200 kgs, let's say 600 per kg. Okay, so how much I'm going to get? 1,20,000. Okay, so I told Sri Mitai, they correcta time ku kuduturu. Nee kudukra Kaju Katliya base panni da I have a one more order waiting where I will sell for 1,20,000. Okay, I will sell for 1,20,000. So 200 kgs, I will convert this by adding milk. In this 1,20,000, 50,000 is cost of Kaju Katli. Another 20,000 is my other expenditure needed to convert Kaju Katli to ice cream. So my profit is 50,000. Now because you did not deliver Kaju Katli, because you didn't give the Kaju Katli on time, I am losing how much? Profit of government kudupana. Instead of giving Kaju Katli ice cream, I will go give him vanilla or chocolate. Avan kepa adukku edukada 600 rupees. Correct? So I lost a special order which was already planned and dependent on your delivery. Then you can claim what damages? Special damages. Meaning, if order or contract 1 is leading to order 2 or contract 2, because I am not able to fulfill this, I also lost contract 2. Then in the contract 2 la vara loss, I can claim as special damage. But idla ஒரு important condition இருக்கு. நான் ஸ்ரீமிட்டாய்க்கு சொல்லியிருக்கணும். I should have informed the order 1 or contract 1 parties. I should have informed Srimitai. What I should have informed? With your Kaju Katli only I will go to government. If you don't give, I have loss. Sollindana I can claim. Are you following, guys? All of you understanding? Okay. Next example. Uber and Ola. Uber and Ola. You fought because he cancelled. You fought with the court and you won the case. How much compensation you will get? 100 rupees. That is called nominal damages. I file a case just for my ego. உன்னை கோர்ட்டுக்கு கொண்டு வந்து நான் கேஸ் ஜெயிக்கணும்டா. நாமினல் டேமேஜ்னா யூ கேன் சூ ஃபார் டேமேஜ். யூ ஆர் கரெக்ட். உனக்கு என்ன வரப்போகுது? ஒன்றுமே வராது. நாமினல் டேமேஜஸ் இன் அதர் கேஸ் வேர் generally people sue for the sake of suing. Are you getting it, guys? Yes, breach of contract. நான் கரெக்டாக முடிக்கல, கரெக்டாக I didn't deliver. Okay, you sue me, but the damage is very negligible. ஒன்றுமே இருக்காது. Urban company electrician did not come home. What is the loss for you? Somebody else will come. 2 hours loss current illa. Okay. Now, if he is not coming, some 100 rupees loss you can claim. Ola didn't come. Are you following, guys? Here you can't tell because Ola didn't come. I didn't go to railway station on time. Train miss பண்ணிட்டேன். 2000 rupees கொடு. இல்ல. அதெல்லாம் கேட்கும். That is what? Special damage. நீ அவனுக்கு சொல்லியிருக்கணும் ஓலாக்கு, நீ அனுப்புற கேப்ல தான் நான் ட்ரெயின் பிடிக்க போறேன், சென்ட் ஆன் டைம்னு. அது எதுவுமே சொல்ல கரெக்டா. ஸோ ஐ கேன் கிளைம் த லாஸ் ஃபார் நாட் கம்மிங், விச் இஸ் நாமினல் டேமேஜ் ஜென்ரலி பிகாஸ் அமௌண்ட் இஸ் வெரி negligible. Can you give me examples where you will sue for the sake of suing but you will not get anything? Can you give an example? You are correct, but sue panna you will not get any compensation majorly. Anyone? Fine. Example, guys. You went to a saloon for haircut. You gave appointment for 3 p.m. Saloon forgot the appointment. So உனக்கு appointment கொடுக்கல. Instead of giving you 3 p.m. appointment for haircut, they gave you appointment for 4 p.m. என்ன ஆகுது? முடியாத வெட்ட போறீங்க. You got angry. You started fighting. You filed a case on them. Court is saying, okay, haircut free. Nominal damage. Are you following, guys? Max. So the nominal, very small damage which is insignificant. Okay, next. Vindictive damages. Under vindictive damages we have 2 points. Okay, let's say now, let's say Ambani and Elon Musk are entering into a contract. And the deal sign பண்றதுக்கு Ambani gave a check of rupees just 1 lakh to Elon Musk. Advance money. Or 10 lakhs வச்சுக்கோங்க guys. 10 lakhs. Contract is 2000 crores project பண்ண போறாங்க ரெண்டு பேரும் சேர்த்து. அதுக்கு அட்வான்ஸா I gave how much, guys? 10 lakhs கொடுத்துருக்கேன் அட்வான்ஸா செக். This check Elon Musk went and deposited in US bank. Check bounced. Check bounced. Then while checking, it bounced because Ambani's bank, let's say ICICI Bank did not properly credit the same. So the check has bounced. But because of this, what happened? Elon Musk முன்னாடி அம்பானிக்கு அசிங்கம் ஆயிடுச்சு. ஒரு 10 lakhs செக்கே உனக்கிட்ட பேலன்ஸ் இல்லையா? Actually balance is there, but because of bank issue the check bounced. Whose bank it is? ICICI Bank. Now because of this my damage is not 10 lakhs. My damage is my name, my credit worthiness. என் பேரு damage பண்ணிடுச்சு. My name is damaged with third party by check bounce even though I had balance. Correct? So this time Ambani will sue, not Elon Musk, sorry. Ambani will sue ICICI Bank for vindictive damages. Vindictive damages na where your credit worthiness is affected. Are you following, guys? Next, last student name. Sorry? I said spelling. IS? See, Isaac. Okay. Example nampa, don't take personally. Okay. Isaac is getting married. Okay. To, let's say, X. Okay. On date of marriage, Isaac ran away. Or marriage cancel பண்ணிட்டான். He is saying X, don't worry. மேரேஜ் ஹால் எக்ஸ்பென்ஸு, சாப்பாடு எக்ஸ்பென்ஸு எல்லாமே நான் கொடுத்துட்றேன். மொத்தமாக செலவழிச்சது 30 lakhs. ஓகே, நான் ஃபுல் 30 lakhs உனக்கு கொடுத்துட்றேன், 100% நான் கொடுத்துட்றேன், போதுமா அது? மேரேஜ் இஸ் கால்ட் ஆஃப் இன் த ஹால் ஜஸ்ட் half an hour பிஃபோர் மேரேஜ். எக்ஸோட ரிலேட்டிவ்ஸ், ஃப்ரெண்ட்ஸ், எவ்ரிபடி, இட் பிகம்ஸ் இன்சல்ட். கரெக்ட்? எமோஷனல் டேமேஜ், பேர் கெட்டு போயிடுச்சு. ஸோ ஃபார் தட் எக்ஸ் வில் ஃபைல் அ கேஸ் அகேன்ஸ்ட் Isaac. That is called again vindictive damage. So vindictive damage, there are two things. If a person's credit worthiness is affected, or in marriage name is affected because of actions, you can sue for this. Here it's not about the amount, it's about the reputation damage. Reputation damage ku evlo vena claim pannalam. Are you following, guys? Last is prefix damages. What is prefix damage in simple? I would have told earlier in concept class also. Let's say if you're not wearing helmet, penalty is 5,000, penalty is 100. Not wearing helmet, if the fine is 5,000, that means it's a penalty. If the fine is only 100, then it's liquidated damages. If the penalty is there, if the amount is there to scare you, bayam puduthrukku vechirukken, that is called penalty. This is not kept to scare you, this is just kept to claim compensation for actual loss or to put a fine. Then it becomes liquidated damages. Indian law does not distinguish penalty and liquidated damages. According to Indian law, both are the same, only British law distinguishes. So again repeating this, let's say prefix this 10 lakhs in the contract. Actual losses 7 lakhs. How much court will give you? 7 lakhs. Imagine prefixed is 10 lakhs. Actual losses 12 lakhs. How much court will give you? They will give you only 10 lakhs. This is the maximum limit. Are you following, guys? This is quick revision of breach of contract and remedies. Quickly, when to go with what. Now we will go to questions. Once we are done with questions, we will close. Question number 1. X entered into a contract with Y to supply 1000 water bottles at 5 to be delivered at a specified time. Thereafter, X contracts with Z for purchase of 1000 water bottles at rupees 4.5. So what X is doing? X double வேலை பண்றான். X is Z கிட்ட இருந்து he is buying one water bottle for, so he can sell to Y at 5 per water bottle. Are you following, guys? That's the question. And told Z that he is doing this for entering into contract with Y. Now Y, here what is happening? X has informed Z. What has he informed? He is informing that I am entering at 4.5 so that I can sell to Y at 5. Z failed to perform the contract, and because of which market price became 5.25. So now market la ipo vaanganona I have to buy at 5.25. Consequently, X could not procure any water bottle and Y cancelled the contract. So what is happening? Because of failure to perform by Z, Z did not perform. Okay. Z did not perform. Z perform பண்ணாதனால Y also cancel the contract. Y also did what, guys? Cancel the contract. Therefore I have a loss now. How much is the loss for me? 0.5 per bottle into how many bottles? Into 1000 bottles is my loss. What is the loss I will claim? 5 500, correct? I will claim how much loss, guys? 1002, 50 paisa. 500 will be claimed as what damage? Special damage. Question is not yet done. What would be your answer if Z had not informed about Y's contract? இப்போ என்ன கேட்குறான், if நீ Z-க்கே சொல்ல சார், இந்த 0.5 பற்றி சொல்லனா, then I would have sold, I would have purchased at 4.5, marketல I could have sold for how much? 5.25, because the market price given in the question is how much? 5.25. That time what will be my profit? 5.25 minus 4.5, 0.75 into 1000, which is 750. This 750 will be general damage. Let me repeat, it's a very good question actually. Z-க்கு தெரியும் சார், Z-க்கு என்ன சார் தெரியும்? நான் 4.5க்கு வாங்கிட்டு 5க்கு விற்க போறேன், என்ன Z-க்கு தெரியுமா? ஸோ Z-க்கு தெரிஞ்சா Z என்ன பண்ணுவான்? He knows that for me loss is only 500. Therefore you can claim only 500 special damage. நான் Z-க்கே Y பத்தி எதுவுமே சொல்லவே இல்லை. நான் சொல்லவே இல்லைனா then you can sell for how much? 5.25, because market price is 5.25. That time my profit is 0.75 into 1000. I can claim 750 as general damages. Are you following, guys? So in this question the final answer is, first case is 500 special, second case 750 is general damage. Are you following? All of you understanding, guys? So that is the case here. First case la வந்து 500 rupees, second case la it is going to be 750. So இதுல வந்து opposite, Z-க்கு inform பண்ணனால you can claim only 500, inform பண்ணாம இருந்தனா you can claim 750. That is because the market price became 5.25. Who will guess that? Are you following, guys? Understood? Hello? It is like in that ice cream example of government ice cream example, government ice cream, my profit is how much? I'm losing 50. But அதே நான் வந்து இவனுக்கு சொல்ல நினச்சிக்கோங்க, ஸ்ரீமிட்டாய்க்கு சொல்லவே இல்லைன்னா, மேபி இஃப் நாட் கவர்மெண்ட், நான் ஒரு பிரைவேட் கம்பெனிக்கு அந்த ஐஸ்கிரீமை I could have sold at, instead of 600, I could have sold at 700. That time you can't argue by saying I would have got more profit. Already fixed another 600. அதே மாதிரி இங்கே fixed another 5. உனக்கு லாஸ் அந்த 5 தான், அந்த லாஸ் தான் நான் கொடுப்பேன் 500. Are you following, guys? Clear? Very good question. It has come in study matலையும் இருக்கு, MTP plus MTP, RTP. Never tested in main exam so far. Good question. Next, question number 2. Can we have someone read question number 2 from online? Yes, we will have Sri Ramani. Sri Ramani, are you there in the class? Yes, Sri Ramani. Before you read the question, you will introduce yourself for the class and then you will read the question. We just want to know your name. Where are you from? Why? Passion, goal. Sorry, start.
My name is Sriramani. I am from Varangal, Telangana.
Okay.
I want to complete my CA foundation.
Okay. No, why you took up CA?
Because to make as a chartered accountant.
Okay, you took it by yourself. Okay. Fine. Passion and goal?
My passion is to make everyone happy with my present, proud. Just want to proud.
That should be goal, no? To make people around you proud is your goal. What is your passion? What do you do in your free time? Things that you do for yourself, like that.
Seeing TV.
Watching TV. Yeah, that's a small passion. Enjoying seeing TV, OTT, all of that. Yes. Thank you, Sri Ramani. Can you read this second question for us, Mr. X?
Mr. X and Mr. X was a
Disc jockey. Yes, continue.
actually
Yes.
at a five-star hotel bar. As per the contract, he supposed to perform even week
Every
weekends,
weekend.
that is
Yes.
twice.
Okay.
Mr. X will be paid in 1500 per day. However, after a month, Mr. X will be fulfill absent himself for the preference.
From
That's
performance. Yes.
actually my phone was not clarity, sir, because I don't have this PDF.
Oh, we have sent in the group. Others got the PDF online. I think உங்க groupல அமைச்சிருப்பாங்களே.
No, sir. Actually, today is my first class, sir, so I don't have that
Oh,
PDF.
okay, fine. Fine. I'll read the question. Does the hotel have the right to end the contract if the hotel sends out an email to X that they are interested to continue the contract and X accepts? Can the hotel rescind the contract after a month? First, have right to end the contract? Yes. No. After a month, X is absenting. Therefore, does the hotel have the right to end the contract? Yes. Second, if the hotel sends out an email that they are interested to continue, X also accepts. Now can you cancel, guys? No. In which of the cases, termination of contract or continuance, can the hotel claim damages that it has resulted as suffered of breach? First case they can claim because there is termination. Second, in continuation they can claim damage. For that 1 month period, after a month. So look at this. First you can terminate. First yes, hotel can terminate. Second, hotel has the right to continue. But once the right is exercised, they cannot cancel. But in both the cases, there is a gap. So in both cases, the hotel is entitled to claim damage as they have suffered loss because of breach. Both the case breach irukku. Breach irundha loss claim pannalam. Okay. This question number 2. Question number 3. Yes, online. Anyone can read it fast. We just have about 8 or 9 questions which we will close. Yes, question number 3. Online. Ishrat, are you there? Ishrat Begum J. Yes. Ishrat, can you read? Okay, we'll have somebody from here to read. You guys can read by yourself. I hope it's visible. Yes, padinga loudly. Online can't hear you, but just read it. Yeah. How much they can claim, guys? How much they can claim? So if you look at this, due to labor strike, M could not manufacture and deliver the machine to Shanti. Later, Shanti purchased this from other manufacturer for 12 lakh. That means how much extra Shanti paid? 12.75 minus 11.5, which is 1 lakh. 1 lakh 25,000 is the one. Therefore, they can claim damage of 1 lakh 25,000. Apart from this, anything else they can claim of? No. So, M will be able to reimburse the compensation which Shanti had to pay to Zenith for breach of contract. One more thing is there. Now look at this. M could not manufacture and deliver the machine to Shanti traders. Later, Shanti traders procured from somebody else. Due to this, Shanti was also prevented from performing a contract which it made from Zenith and was compelled to pay compensation for breach of contract. So that compensation also who will give? M Limited. If you had informed M Limited about the same, that's what they will say. Regarding the amount of compensation which Shanti were compelled to pay Zenith, it depends upon the fact. You can give both answers. Depends upon the fact. That means first this 1,25,000 is what damage? General damage. The second one, it depends upon the fact whether M knew about the contract, whether M knew about the contract or not. If they knew about the contract, then you can claim the compensation. Are you following, guys? Clear, all of you? Fine. Next, question number 4. One second, online they have some doubt. Okay. Fine. Yes, yes. No problem, Ishrat. Yeah. Question number 4. Yes, quickly read it. Last row, Dhanya, read it the question loudly. So basically, you are traveling in bus. During the travel, the bus stopped, so we had to go and stay somewhere else. Can I claim damage for this? Yes. General damage can be claimed for direct loss, but because of that she fell sick. That is an indirect loss. That is an indirect loss which you cannot claim for that. So look at this conclusion on the base of above provision. It can be said Murthy can claim damage for personal inconvenience but not for medical treatment because there is a remote or indirect loss. In the provision also you will see in general damages. In ordinary damages, such compensation is not to be given for remote or indirect loss that you have sustained. Are you following, guys? That means if auto man cancel the auto, I couldn't go to station. For that act I can claim damage. Auto varadanala 100 rupees, okay. But because of that I didn't go to station on time. I missed the train. And the train kasu kuduna kuduka mattom. Are you following, guys? Clear? Inform panna kuduthiruppan. If I inform the booking, I am booking at 5 p.m. auto so that I can go to railway station on time. I'm a 5 p.m. varama 5:30 vandaan, or he cancelled at 5:20 because of which I missed the train. Then you can claim damage. Okay. Next. Question number 5. We'll have someone online again. Read it. Yes, somebody online. Padma Shri, can you read the question?
Yes.
Yes, Padma Shri. Before that, hold on. Before that, did you attend the class yesterday?
Yes.
Yeah. So introduce yourself, then you can read the question. Go ahead.
So I'm Padmashri and I'm from Chennai.
Okay.
I really don't know the reason why I'm doing this course.
You don't know the reason, then how you got into the course? How did you register? சொல்லுங்க பரவாயில்ல. Parents.
I took moments in 11th and 12th.
Okay.
Don't know what to do after 12th.
Okay.
Didn't want to waste 3 years on BCom degree.
So many friends took CA, so you took CA, is it?
Yes, sir.
Okay, super. Friends எடுத்தாங்க so நான் எடுத்தேன். Are you enjoying the course now?
Yes, sir.
Superb. Okay, your passion, goal.
Passion, just to listen to music and small things.
Okay,
That's it.
listen to music. Okay, goal.
Follow clear foundation.
I don't know. Clearing foundation, inter, final is everybody's goal. That's why we are spending time on a rainy day in class. What is your other goals in life apart from CA? General goals that you have. Yes, yes, fast.
Many things about it, sir.
You have to think until otherwise we will not continue now. Everybody are waiting to for you to read the question soon. Fast. Any goal, small goal, big goal, tomorrow's goal to watch, let's say some movie, anything.
Watching movies.
Watch which movie is the goal. Which movie if you watch you will achieve the short term goal.
Pushpa.
Pushpa 2, I think. Super, okay. So your short term goal is to watch Pushpa 2. Enjoy. Yes. Question number 5. Yes, now you can read Padma Shri.
Sheena was a classical dancer. She entered into an agreement with Vitiating for 60 dance performance. As per the contract, she was supposed to perform every weekend and she will be paid rupees 10,000 per performance. However, after a month, she was absent without informing due to her personal reasons. Answer the following questions as per Indian Contract Act 1872. Whether management of Shittal Vidyamandir has right to terminate the contract. If the management of Shittal Vidyamandir informed China about its continuance, can the management still rescind the contract after a month on this ground subsequently? Can the Shittal Vidyamandir claim damages that it has suffered because of this breach in any of these above cases?
Same similar question, guys. Whether the management of Sheetal has the right to terminate the contract? Yes. If the management of Sheetal informed Shina about its continuance, can the management rescind the contract? No. Can Sheetal claim damage suffered because of loss in other above cases? Yes, you can claim in both. Adhe question anga hotel, inga school. That's it. Next. Question 6. Let me read this past exam paper for 2 marks. Quickly we'll finish. In light of the provisions of Indian Contract Act, answer the following. A and B entered into a contract to supply unique item, alternate of which is not available in the market. A refused to supply the unique item. What directions could be given for breach? Here you will claim damage. Huh? No. Suit for specific performance because வெளியில இது வாங்க முடியாது. Only you can deliver. So give it to me. Therefore, this is like that STR example. This mere monetary damage may not be adequate. Even in the movie, STR is giving some money, it's not adequate. We want to finish the movie. Therefore, in this case, you will sue for specific performance. Court may direct A to supply the item to B. That means this is nothing but specific performance. Asking him to supply to other person is specific performance. Are you following, guys? Clear? Next. Question number 7. Yes, online can we have somebody who's yet to read a question, guys? So far I have been silent. Saranya S. Saranya S, are you there? Hello. Not there. Oh, Saranya is left actually. Sorry. Can we have Harshini to read it? Harshini, yes. Okay. Harshini, not. Let me read. Seema was running a boutique in New Delhi. She has to deliver some cloth to her friend Kiran, who was putting up an exhibition at Mumbai. Seema delivered the sewing machine and some cloth to a railway company to be delivered at a place where the exhibition was to be held. Seema expected to earn an exceptional profit from the sales made at this exhibition. However, she did not bring this fact to the notice of the railway authority. Goods were delivered at the place after the conclusion of the exhibition. Can she claim damage from railway authorities? No, because she did not inform railway authorities, but she can only claim what damages? General damages for delay in delivery. That's the answer. Since no notice about the special circumstance was given to the railways, she could not recover loss of profit. Therefore, Seema can recover only loss in ordinary course of business. That she can recover. Are you following, guys? Clear? Understanding? Next, idhe question I am not reading again. Disc jockey, 5-star hotel. You know what is the answer. No, yes, yes for both. Correct? Right? Sorry, right? Yes, no, yes for both. நான் படிக்காமே சொல்லுவேன், but examல don't do like that, guys. இந்த மாதிரி மாத்திடுவோம். Just go through that. Okay. I will anyway give you the full PDF, guys. Now you have PDF of only Contract Act. It's getting ready for Sale of Goods Act, LLP company. I will collate everything and send you one final booklet of all the PDFs. If that is there for you, no need to refer to any past exam RTP எதுவும் தேவையில்லை, எல்லாமே இதுலயே இருக்கும். Okay. Of course, RTP, MTP is available in different places, but you have to sit and find them. That too, that will have direct question, case study. Do you want to learn if they're asking what is penalty versus liquidated damages or penalty versus liquidated? Are you going to search, read that in RTP? உனக்கு already தெரியும். So only case study. Okay. Hard copy we will check with, just check with the team. If they're giving it, you can collect it. Okay. Next, M Limited contract with Shanti Traders. Did you get hard copy for other subjects? வந்துச்சா? அப்பா நீங்கள் செக் பண்ணிக்கோங்க. ஓகே. ஓ எதுக்கும் இந்த மாதிரி மெட்டீரியலே கொடுக்கலன்னு சொல்கிறீங்களா? ஓ ஒன்லி ஸ்டடி மேட் வாஸ் யூஸ்ட். ஓகே ஃபைன். M Limited contract with Shanti Traders to make and deliver certain machinery to them by 30th. Which question? Same. 11.5 lakhs, 12.75. So what is not tested in this chapter? Now if you are smart, if you are going to do expected questions, okay, எந்தெந்த questionsல case study இன்னும் அவன் கேட்கல. See, anticipatory breachலாம் examல கேட்டான், but direct. What is, how we asked in exam in the past, differentiate between breach and anticipatory, actual breach and anticipatory breach, 4 marks. I am not here to teach that. அது நீ வீட்டிலேயே படிச்சுக்கலாம். ஓகே. கேஸ் ஸ்டடி எங்கெல்லாம் கேட்கல, ஆன்டிசிபேட்டரி கேஸ் ஸ்டடி கேட்கல. ரெசெஷன் they have asked case study, just now we saw. Injunction they are not asked case study. அந்த ஜாக்கி தான் suit upon quantum merit. ஓகே. So ordinary special cases. Vindictiveல கேட்கல case study. Nominal also they have not asked case study. So in my expected questions, I will add these topics also. Are you follow? That's how I prepare it. You don't have to take the effort. We will do that. With this, we are done with what, guys? Indian Contract Act oda all questions from unit 1 to 6 is done. What is left for us in Indian Contract Act unit 7, 8, 9? These 3, please read and come for the next class. Next class we will do this. Once this is done, it becomes easier. Sale of Goods Act இருக்கிறதே 4 unit, Indian Partnership Act இருக்கிறதே 3 units, and then Negotiable Instrument Act just one PDF. There is no unit, அதில் யூனிட்டே கிடையாது. And then LLP Actல ஒரே ஒரு unit, we just have one set of 10-20 questions, and then similar with Companies Act we will go. Indian Regulatory Framework is a new addition, so பெருசா I don't have any questions. Full IRFல இருக்கிறதே 4-5 question தான், அதான் திருப்பி கேட்பான். Okay, so majors only these 3. So the same order we will go. I will finish 7, 8, 9, then SOGA, then Indian Partnership Act. For all this, concept recording is available, guys. I have given it for free. It's available for long time. Get the link and take it, or you can WhatsApp me. I'm sure all of you have my number. Wait, let me write that at other neat alda. 7550137279. Anything you want, you can always WhatsApp. I will give it to you guys. Of course, I will reply a little later, but I will definitely reply. Or 1 week, 10 days kulla vandru reply. That's the worst case. 1-2 days varum. Sometimes miss panana, again you drop a reminder. There are 500 plus 100 message. Time agum, guys. But you can always call me. Anything important now, you call me also. Fine. Yeah, that's it for the day. You can take this number if you want. Any doubts before which we can close, guys?
Sir,
Yes.
Sir, actually, I want PDF for all Indian contract.
Yes, I think the team has shared it yesterday in the group. You all get the PDF? Priya, Padmashri, can you confirm?
Yes, sir, I have got the PDFs and she asked me also. I have transferred it.
Yes. Sriramani, get it from Priya. If you're not getting, you just WhatsApp me. I will send it to you. Not an issue. Or you WhatsApp the admin team. They will send it to you. Okay. Fine. Anybody else? Any other doubts? Google Meet la ஆளே இல்ல இருக்காங்க. Kirtika is there. Very good, Kirtika. Fine. See you guys. Thank you. Bye bye. Have a great day. So let's quickly finish off Unit 6 discussion, guys. What is Unit 6? Contingent and quasi-contract. If you look at the main exam, if you're lucky, they will ask both. Sometimes they will ask from contingent, sometimes they will ask from quasi, sometimes rarely the whole chapter is skipped. Now we are going to discuss only 4 questions from contingent and quasi contract in the book. These are case study based questions. I am not discussing direct questions. Thankfully here in contingent and quasi also, here we have only one concept. Here also we have one concept. Quickly in 5 minutes I want to revise what is quasi contract, what is contingent contract. Okay, what is quasi contract? Quasi contract is very simple. It says what is a contract? Agreement plus essential elements becomes a valid contract. We have many essential elements: offer and acceptance, free consent, capacity to enter into contract, all those points. Now quasi contract is an exception to this rule. It says a contract there has to be offer plus. Here there is no offer plus acceptance. Automatically by law a contract is created. It is created so that one party should not suffer at other party's gain. Let me give an example. You are staying in your house. Zomato is coming to your house. Zomato delivery is coming to your house, ringing the bell and giving you Domino's pizza on 1st Jan. You are saying you didn't order. Domino's Zomato person is saying your address only is given. Here, take the pizza. What? It's already prepaid in solran. Veg pizza. What you'll do? It's hot. Came straight from the restaurant. What you'll do? Solunga. You will take it and you will eat it. 1st Jan, you will think, okay, Domino's free kudukranga pola. A pure long bag I ordered, so they're giving for free. Then after 20 minutes, he again came back to the house. Sorry, sir. Address is wrong. By mistake, I came here. I should have gone to 1st floor. I came to your house in ground floor or 3rd floor, whatever. Please give the pizza back. நீ என்ன பண்ணுவ? சாப்பிட்ட 20 minutes over. That is not sufficient to eat one pizza. I will eat in 5 minutes itself. You came late. Now he's saying, okay, then make the payment. What you will tell? You have to pay. எதுக்கு சாப்பிட்டா போனா? ஃப்ரீயாக கொடுத்தா உனக்கு. So, and he told also while giving, it is prepaid, correct? So the intention of Zomato delivery was not to give it to you for free. Here there is no question of offer, acceptance, nothing. Quasi contract says you do not have the right to enjoy things for free when the intention was not to give it to you for free. Suddenly one day you woke up, your bank account has 100 crores balance. Lucky Bhaskar, money came to your account by mistake. Immediately go withdraw that 100 crores and put in suitcase and run now. You have to return the money. Money was credited to your bank account by mistake. Once I come mostly to class in auto for last 2-3 years. Auto or cab I will take. Why I will not come in car now? During the travel I can just reply to some message, take some calls. So once to auto Anna I had to pay 200 rupees. By mistake I was absent minded that time. Instead of 200 I paid him 20,000 rupees. Google Pay I added 2 more zeros and sent off, which I forgot. Later when I was checking balance, that day evening I was checking, balance illa, yesterday only I added some money. Balance definitely irukunu. Then I checked the transaction history. I paid the auto person 20k. His number was there. I called him. He picked and told. I told, sorry sir, by mistake I paid 20k. Can you send 19,800 rupees back? Very kindly he sent the money back. That means now money paid by mistake, he has an obligation to return it back to me. That is quasi-contract. So what is quasi-contract? Act has given 5 quasi-contracts. Those 5 points you have to remember. One is not minor. Sorry, minor, what is it? Minor, you have supplied what? Necessities for minor or person who are dependent on the minor, okay, or any person who is even unsound mind, all those people are included. Second, payment made by interested person. Sir, what is this payment made by interested person? You are in the class, I'm in the class, I ordered lunch, Zomato Anna came and delivered my lunch. Because I'm in the class, some student made the cash payment to Zomato and Zomato took the food and left, took the money and left. My lunch is here. Now I'm coming out. Student is saying, sir, because you are in class, I didn't want to disturb you. It was only 150 rupees. You ordered some milkshake. I paid the money. So payment made by interested person. On behalf of me, he paid. Now can I tell the student I won't give the money back? I have to give. Quasi-contract. Okay. Next. Third one. What is it? Obligation of a person enjoying a non-gratuitous act. Example is the Zomato being delivered to your house. Non-gratuitous. I didn't want to deliver the pizza to you for free. Let's say in your house, the person delivering milk is giving milk every day. You also kept drinking that milk and then he's coming and asking money. You can't tell I never asked for milk. Then next point. Responsibility of finder of lost goods. I know you all know this point. If you find a lost good, it's your responsibility to return it. While returning, if you incur some expenses, you can claim that money. Some more concepts here, sir. If the goods are perishable in nature, then you can sell the goods because to avoid that loss. And that money also you should give it back to the true owner. Okay. You found one ring. Police is coming and saying, give it to me. I will take care. Will you give it? No. Whoever finds it has the full right to keep it. You can't, even if police asks, you should not give. You can give it, but you can choose to deny also. Because I have the full right. Last one, payment made by mistake, that bank account or coercion. Force pani vaangirkan, sir. All these cases becomes a quasi-contract. Other one is what? Contingent contract. Is it wagering, guys? No, it is not a wager. Simple. I am telling. In 2025 IPL, if CSK wins the IPL, I will give all of you each one plate of biryani treat. This is a contingent contract because if CSK wins, you will get what? One plate biryani. If CSK doesn't win, then what you will get? Nothing. So contingent contract la, I have a chance to lose or nothing. I have a chance to lose or nothing will happen. For you, you have a chance to win or nothing will happen. You have a chance to win or nothing will happen. Are you following, guys? Again, I'm saying in 2025, if RCB wins IPL, I will give each of you 1 lakh rupees in solra. It will happen now. I'm not saying. You're saying no. Okay. Now, what I'm saying is, if RCB wins, each of you I will give 1 lakh rupees. This contract is valid till IPL 2025 is over. Huh? No. It's valid only till first half of league stage. Because after that, RCB will get knocked out. Contract is not valid. Still IPL is going on. But still RCB cannot go to playoff now. So until that event possibility is there, it is there. If they win, I have to give all of you 1 lakh. I'm not entering into contract. By example, okay. So contingent contract now, one party can win or nothing or lose or nothing. Same party will not have the chance to win or lose. Are you getting it, guys? Under contingent contract, we have some rules. Those rules you will go through. Those are theory points. Now straight away, let's get to questions, guys. X, a minor, was studying in MCom in a college. Sir, how sir minor is studying MCom and all? Don't ask me. Okay. Those days, minor used to get married when they were 12 years, have kids when they were 15 years. So before 18, everything will get over for minor. So college படிக்கிறதுல ஒண்ணுமே கிடையாது. Okay. On 1st July 2019, he took a loan of 1 lakh from B for payment of his college fees and to purchase books and agreed to repay by 31st of December. X possesses assets worth 9 lakhs. On due date, X fails to pay back the loan. Now B wants to recover the loan from his assets. Can he recover, guys? Yes. What concept? Quasi-contract, payment out of your personal assets in case of necessities. Yes. Second, P left his carriage on D's premises. Landlord of D seized the carriage against the rent due from D. P paid the rent and got his carriage released. Can P recover the amount? Answer is yes. Payment made by interested person. I'm staying in my friend's house. My luggage is in the friend's house. Friend rent pay பண்ணல. So landlord seized the house. எனக்கு என் luggage வேணும். So I went and paid the money. Now I can get the money from my friend. Payment made by interested person. Are you following? புரியுதாப்பா? Next, PQR, a hospital in Delhi, recruits A on contract basis for 3 months. The hospital management promises to pay Mr. Dr. A lump sum amount of 1 lakh if Dr. A tests positive for COVID. So COVID time la doctors were also scared to work. So hospital is saying, doctor நீங்க please வந்து வேலை செய்யுங்க, எங்க hospital ஆள் இல்லை. You work for 3 months. Suppose in the 3 months la உங்களுக்கு COVID வந்துச்சு, then we will pay you 1 lakh. If Dr. A tests positive for COVID during 3 months, identify the type of contract and what will happen if he does not get COVID. What type of contract is this? This is contingent contract, because I will pay 1 lakh if you get COVID. If you don't get COVID, I will not pay anything. So this is, identify what rule? This is contingent contract on happening of an event within fixed time. There are many rules. So there is one rule, contingent contract happening within a fixed time. If within 3 months you get COVID, I will pay. If you don't get COVID in 3 months, nothing will be paid. What if you get COVID after 4 months? Nothing. Here only 3 months time is given. Okay. அதுக்காக for 1 lakh he will go get COVID. COVID patient அங்கே தான் இருக்காங்க. I will go let take his water, drink his water, I will get COVID. No. Okay. 1 lakh important, 10 lakhs important, life important. Life. Rohan found a wallet in restaurant. First word லே கண்டுபிடிச்சிட்டேன். What concept? Finder of lost goods. என்ன பண்ணும்? திருப்பி கொடுக்கணும். படிக்கலாம் question. He enquired all the customers present in there, but true owner could not be found. He handed over the same to the manager of the restaurant to keep the wallet till the true owner is found. After a week, Rohan went back to the restaurant to enquire about the wallet. The manager refused to return to Rohan. Should he return to Rohan? Yes, because Rohan has now found the wallet. He has all the rights of the wallet against the whole world, saying that it did not belong to him. In light of Indian Contract Act, can Rohan recover the wallet from manager? Yes. Look how they wrote the answer. A person who finds goods belonging to another, takes them in his custody, is subject to same responsibility as if he is a bailee. So if you are a bailee, to take proper care of the property as a man of ordinary prudence would no right to appropriate goods to restore the goods. In light of above provisions, manager must return the wallet since Rohan is entitled to retain the wallet against everybody except the true owner. That's it. Are you following, guys? Write in the own words. That's about it. Clear? Understood? Easy? With this, we are done with unit 6. Quick revision. Of course, in our crash, this is what we can do. We will do more questions again later. I have a set of own questions that I have discussed and expected questions. We will do it that time. So that's about it, guys. Thank you. Any doubts? No doubts, guys. Fine. Thank you.